versus Barry Johnson. File numbers 255095 and 255107. Record should reflect Mr. Johnson present before the court here today. If I could have counsel with your appearances tonight.
Ryan Ziegler on behalf of New York.
Kyle Travis on behalf of Mr. Johnson.
All right, this is the date and time set for sentencing. Mr. Johnson, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, Your Honor.
Travis, are there any additions, deletions, or corrections to that report?
Your Honor, not that I'm aware
Okay. Are there any challenges to the scoring of the guidelines?
of. No, Your Honor.
Mr. Ziegler, do you have any additions, deletions, or corrections?
No, Your Honor.
Do you have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, Mr. Johnson clearly has an issue with controlled substances. He has 2 prior felony convictions that are both drug related. He's had 2 files here, both drug related. When he was picked up for his warrant, for one of these cases, he was found with more cocaine in his residence, giving rise to the dismissed file. Mr. Johnson clearly has an issue that he needs to address. His record is not horrendous as of yet, and these offenses are not so egregious that he is getting prison recommendations, but I think he is running out of time in that regard. The guidelines here are 0 to 9. I think a sentence in the middle of the guidelines is very appropriate, and so I would support the recommendation of PSI author. However, Mr. Johnson needs to understand that if he continues to return to this court or to another court on these types of charges, guidelines are going to continue to grow, and recommendations on the lower middle end of the guidelines are going to dry up. I hope that he understands that his name and his history are well known to me and are well known to local law enforcement. And if he continues down this road, prison is the likely next stop. For today, Your Honor, I would just ask the court to adopt the recommendations.
Mr. Travis?
Thank you, Your Honor. I've known Mr. Johnson for a while now. He does very clearly have a very real drug problem. I am somewhat encouraged that he's not so much escalated his problem. These are regular narcotics cases. That's like a great thing, but at least for Gary, that he's not progressing in his use. He knows he needs to stop. He's had some successes at that, but generally not been great. I mean, we talk about what happened in the interim of these 2 cases, and he's pretty honest. He's not going to try and tell Your Honor that, oh, I was clean for the 8 months in between. He's got a real problem. He's been clean for a while now. He has noted he's got a probation violation in Grand Traverse. So we don't know what's going to happen there, but he's still facing further consequences from this happening. That hasn't been resolved. He's been arraigned, but nothing's really happened with that yet. So I suspect the way things have been going, after he finishes whatever sentence Your Honor gives him, he will then go over to Grand Traverse and still have more issues to deal with. He's got a lot of potential. I don't know how his father's doing right now, but I know his father was in the sobriety court in Grand Traverse County, and when I talked to him about that, was doing quite well. That's part of the issue Gary has. His father has a pretty extensive criminal history too, and he's had that kind of following him around since he was this whole time here in Kalkaska. But he knows that he's the one who's got to change that path. So we would ask the court to follow the recommendations. Thank you.
Thank you. Mr. Johnson, anything you wanted to say today?
I'd just like to apologize to the courts and the community for my actions. It was fueled by my substance abuse issue. It was irresponsible, selfish. I need to change the people I hang out with, or it's going to be an escalating door for me. That's all.
All right, I read through the report. I'm familiar with what happened in this case. There's also information in that report about your background and your history. through this PSI as well as the PSI that was done most recently in Grand Traverse. So I've got a good handle on what was going on here that brings you before the court, as well as your past history, past offenses, and your personal circumstances. I agree with Mr. Ziegler. I mean, you're coming before the court enough that I'm starting to recognize you, and I'm on the bench in 3 different counties. I probably have at any given time 300 cases on my docket. So the fact that I'm recognizing you means that you're coming to court way too often, and you're going to end up going to prison sooner or later if you don't get a handle on things. And so I hope that you're going to take this opportunity of a relatively light jail sentence. I agree that a sentence in the middle of the guidelines is appropriate as a kind of a warning shot that you're running out of chances now. So the court is going to follow the recommendation and sentence you to 4 months in the Kalkaska County Jail. Again, that's right in the middle of the guidelines. You do have credit for 96 days served. Court is going to order a crime victims assessment in the amount of $130, court costs $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence. And Mr. Travis, if you can have Mr. Johnson acknowledge his appellate rights. We are admitted to the custody of the county at this time, Mr. Johnson. We're waiting for Mr. Oh, there's Mr. Seeger. Okay.
All right.
This is Mr. Dennis' case.
It is, Your Honor.
Okay. Court calls People versus Lloyd Dennis, file number 255118. The record should reflect Mr. Dennis is present here in the courtroom today. Have the counsel put your appearances on.
Ryan Ziegler.
Mr. Seeger, how did we want to proceed with this?
Your Honor, it's my understanding that people about for Mr. Dennison at this time.
Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Dennis, have you had an opportunity to speak with Mr. Seeger about this plea agreement?
Yes.
Is that how you wanted to proceed today?
Yes, Your Honor.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Thank you, Your Honor.
Thank you. Mr. Dennis, are you currently on any kind of probation or parole?
Yes, provision.
Where's that out of?
Benzie County.
Okay. Do they know that you're entering this plea here today?
They're about to.
Okay. That means they don't know yet. Okay, so you understand that by pleading guilty here, that could result in a violation of your probation and that you could face additional penalties in Benzie County? And the maximum possible penalty for this added count 2 of possession of analogs is up to 2 years. Do you understand that? With all of that in mind, what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Thank you, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you can only do that by leave. That means you have to ask the Court of Appeals to hear your case. They can say no, and then that would be the end of any appeal. Do you understand that?
Yeah.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty to this charge because you are actually guilty of this charge?
Yes.
The information I have indicates this happened on April 1st of 2025. Is that the correct date?
Yes.
On that date, were you present here in Kalkaska County?
Yes.
And on that date, did you have possession of a controlled substance that was or contained some fentanyl?
I did, Your Honor.
Did you have any legal right to have any amount of that substance?
No.
Did you know that you had that substance in your possession?
Yes.
Mr. Ziegler, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you. Mr. Dennis, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important between now and then that you stay in touch with your attorney, Mr. Seeger. Before you leave court today, you're going to need to go next door to the probation office, and they're going to get you a packet for a pre-sentence report. Do you have any questions? Thank you. That's all. Mr. Williams, were you ready on Ms. Green's case?
Yes, sir.
Okay. People versus Heather Green, file number 255053. If I could have counsel put your appearances on, please.
Ryan Ziegler on behalf of the people.
Trustee Williams representing the screen.
Mr. Williams, can you tell me what the status of this is from the defense side today?
Yes, we would intend to place a plea on the record today. We do have an agreed amount of restitution that is part of that plea. We anticipate the restitution being paid before sentencing. We're simply waiting for a piece of property to close. I would ask the court to consider allowing 6 weeks before scheduled sentencing just to make sure the restitution is paid as a result of all of that, because of the lack of Ms. Green's criminal history, with people offered a misdemeanor to resolve the case.
Mr. Ziegler?
Your Honor, the offer would be that so long as restitution is paid in advance of sentencing, the plea agreement would be to false pretenses, $200 to $1,000, which is a 1-year misdemeanor.
But we would stipulate to the 20. What is it?
It's just over $20,000 restitution.
Okay. All right. Ms. Green, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes.
Is that how you wanted to proceed today?
Sure.
Can you raise your right hand, please? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sure.
Thank you. You can lower your hand. Ms. Green, are you currently on any kind of probation or parole?
Just I have to come in.
Bond. She's
Yeah.
Okay. You understand that the maximum possible penalty that you could face for this charge would be up to 1 year in jail? All right. With that penalty in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself at a trial if you want it. You understand all those rights. And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal your plea today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that? And then I'm assuming, Mr. Ziegler, if the restitution was not paid by sentencing, that you would withdraw the offer, is that right?
That's correct, Your Honor.
Okay, so Ms. Green, I'm sure Mr. Williams has explained this to you, but if for some reason you don't pay that restitution, that means that this plea agreement would be off the table. You would get all of those rights back that I discussed with you, and you could either decide to go to trial or try to come up with some other type of arrangement. Do you understand that?
Yes.
Has anybody threatened you with anything to get you to plead guilty? Has anybody promised you anything other than what we said here in court today? Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
Mr. Williams, would you be able to establish a factual basis with?
I would, Your Honor. Mrs. Green, you in Kalkaska County, you received funds that were for your daughter from the state of Michigan, correct?
Yes.
And in the county and town Kalkaska, you converted those funds for your own personal use, correct?
Yes, Your Honor.
No.
Sorry.
Yes. Is that, yes, sorry, just so
Yes.
the record's clear. So you took the funds that were your daughter's funds, converted them for your own personal use for yourself, correct?
Yes.
And you had no intent on. You did not have permission to do that, did you? From your doctor? We're not getting into,
Yes.
correct, you did not have permission for
I
the
did.
funds we are talking about,
Yes.
correct? And that all happened here in Kalkaska, correct?
Yes.
And those funds were in excess of $1,000, correct?
Yes.
Thank you.
Mr. Ziegler, are you satisfied?
Your Honor, I think there needs to be some testimony about a false pretense. I think that's probably a factual basis for larceny by conversion if the court wants to take the plea as the larceny by conversion and apply it to the false pretenses. But there was no testimony that there was some falsehood used to obtain or to divert the funds.
All right, Mr. Williams.
Did she obtain the funds by means of making representation to the department that certain things were true? And not true?
Okay, that's fine.
Yeah.
You made representations to the department, I say department, the state agency of certain facts that were true that were not actually true regarding those funds, some of those funds, correct? That's part of, we're not discussing some of the case, I'm just talking about how. Well, correct, just you represented certain facts to the state agency that were incorrect, not factually false, correct?
Yes.
Okay. All right, with that, Mr. Ziegler.
I'm satisfied.
All right. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Ms. Green, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for sentencing in February, so that's about 60 days. It'll be early February. I don't have the date, but you'll be provided with the notice of the date and time of that hearing, just like you were for today's hearing. It's important between now and then, especially in your case, that you stay in touch with Mr. Williams so that you can make sure that those funds are paid back as part of the restitution, because as we've said, this whole thing hinges on that. So it's very important that you stay in touch with your attorney so that he can make sure that we get what needs to be done, okay? Before you leave today, I'm gonna have you go across the way here to the probation office and touch base with them. They're gonna give you a packet for a pre-sentence report, okay? Mr. Williams, anything further today?
No, Your Honor, thank you.
Mr. Ziegler?
No, Your Honor.
Okay, thank you, that's all.
Your Honor, I do have a question.
Yeah, hold on,
I just-
Mr. Go ahead.
I just want to clarify to make this sense. So she is entering a plea to a felony, but if she pays
Oh.
restitution, okay, what count did she plead to then?
It'd be an added count, I want to say 6 of our false pretenses, 200 to 1,000. And it's contingent upon the restitution being paid before the time of sentencing. If not, then we withdraw the plea.
Okay, all right, makes sense. So we'll be doing a misdemeanor PSI.
Correct, yep.
Can I get that back?
Yes.
You're all set, Mr. Williams, thank you.
750.2183A.
Thanks. Was the PAC code for Dennis the same as the earlier analog?
For the analogs, yes.
Yeah. Thank you.
Mr. Travis, I'm gonna call Mr. Galvanic's case. I don't see anybody signing in. I know he's not present, but let's go on the record in that file. Excuse me, that is file number 255066, People versus Dennis Galvanic. If I could have counsel for your appearances on that.
Ryan Ziegler, on behalf of people in our.
Kyle Travis on behalf of Mr. Galvanic.
So Mr. Galvanic is not present here in the courtroom today. I believe the information I have is he's lodged somewhere, but we don't know where. Is that your information as well?
I don't know. Yeah.
Well, let's start with this. Do you know where he is?
I don't.
Okay.
So I've gotten, he was extradited from Kalkaska. I believe he was extradited to Jefferson County, Colorado. I made a number of inquiries to try and figure out what's going on in Jefferson County. And I can't find any record of him there. And they've got a thing to look and see who's in the jail there. He's not listed there. I've tried to go through public court records and see what the status of his case is. I can't even find a case. I've tried to call on the phone, tried to send emails to a records department. And everything I'm getting is nothing from Jefferson County, but I do believe he was there at one point and had a felony that he got extradited to. I just can't find anything about that. And it's difficult to actually talk to a person the way their system is set up. Everything's seemingly online, but I'm not getting anything there, which is a bit of a head scratcher because I think either which way he had a case there at one point, even if he's not there. But that's the head scratcher to me, is I'm not even able to find a piece of that. But that's where it stands.
All right, Mr. Ziegler.
Your Honor, I know he was extradited to Jefferson County, Colorado. This was back around August, maybe July or August of this year. It was, if I recall correctly, for a felony assault there. Our thinking at the time was that he would probably be facing prison there, and this would kind of, once that happened in Colorado, this would kind of go by the wayside. But I don't have any further update as to where he's at. My best information is that he bonded out at some point in Colorado, and I don't know what the status of his case is there. I would just ask the court to issue a warrant for his arrest, and if he turns up in Colorado, we would have a hold on him until such time as he resolves his Colorado case.
Okay. Given the circumstances, I think it would be reasonable to issue a bench warrant for his arrest. That way, if he's found in Colorado, there would be that hold. If for some reason he returns to Michigan, then we have a way to bring him into custody and get him before the court. So the court will request the prosecutor to issue a bench warrant. I'll sign that warrant. And then we'll proceed further when Mr. Galvanic's whereabouts are located or he's arrested.
Thank you.
Thank you. Is Mr. Barnes in Wexford?
He would be in Charlotte.
Charlotte. All right. We do have a writ. It's not present. So, get a hold of Charlotte County.
Oh, yep.
See if they're gonna have Mr. Barnes available. We'll see about Mr. Barnes' whereabouts.
Your Honor, he was, we did a writ for in person for Mr. Barnes because apparently this is Charlevoix's circuit court date as well, and they weren't sure they were able to produce him via Zoom. So we did an in-person writ. I don't know if he was brought or not.
Jerry, can you check and see if we have Mr. Barnes here? Joshua
This was
Barnes.
dissolving. As they call it. They weren't sure they would be able to produce until the afternoon.
Okay.
Yeah, I was assuming that it was just by Zoom, but yeah, it obviously says in person, so.
We did a Zoom one first, Your Honor. That would probably be.
Oh, that's where I'm confused. My docket says by Zoom, so that's.
Yeah.
Okay.
Correct. We had to rush in person right at the last minute to make sure it would be available. Right. Just figure we'll do it in person, that way. We get this done. I'm just.
Down, they said they're assuming he is appearing from Charlevoix by Zoom.
Okay, so we don't have him in our jail.
That is correct.
All right, gentlemen, how do you want to proceed?
I don't know that we have much option other than to reschedule. Mr. Barnes is under sentence in Charlevoix for approximately a year.
Okay.
So he'll be there at the next date.
Okay.
We were intending, I think, on entering the plea and asking for consent.
Mr. Travis, do you have an objection to resetting this?
Well, not really, but he's no longer technically getting credit. It was gonna be my request to ask Your Honor to give him time served on this. The plea is to a misdemeanor use. He's got 3+ months of credit in Kalkaska, and now we're probably gonna go on 2 months of time in Charlevoix, but absent that, no, obviously we've got to do what we've got to do.
Yeah, so typically in those kind of situations where it's no fault of the defendant, if it's a delay outside the defendant's control, I would allow for jail credit based on that delay if they're incarcerated.
Thank you, Your Honor.
So I guess, Mr. Ziegler, if you can just communicate with the sheriff's department, they may have not realized it was in person. Obviously, they didn't go get them. So you can just do that extra communication so that they're aware.
We'll make sure it happens next time. Your Honor.
Okay. All right. Last case of the morning is Mr. Taylor. Is he?
Don't, no, I'm gonna go check and see if he's out here.
Okay. We'll take a short break and then back on the record. All right, Mr. Barnes, we're gonna need you to unmute on your end there. While we're waiting for that, we'll go on the record in People versus Joshua Barnes, file number 255075.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Barnes, Your Honor.
All right, Mr. Barnes, we've got you now. Can you hear me okay?
Yep.
Okay.
Yeah.
So, Mr. Travis, how did we want to proceed on Mr. Barnes' file today?
Thank you, Your Honor. Your Honor, I was able to get a copy of Mr. Barnes's sentence and conviction out of Charlevoix County. I was able to provide that to Mr. Ziegler. And because of that, it's my understanding, would make an offer to resolve this matter with the use of narcotics, 1-year misdemeanor. I tried to speak with Mr. Barnes, but we were not able to put that together through the Charlevoix County Jail, but he does know about this deal. We've been talking about it for quite some time. So absent him having any questions, he wants to accept that plea to use of narcotics.
With no habituals?
No habituals, misdemeanor.
You want your.
Okay. Mr. Barnes, were you able to hear all of that?
Yes, sir. Yes, sir.
Do you have questions for your lawyer? Did you want to go forward with that plea agreement today?
Yeah, that's fine. Yeah, that's fine.
All right, can you raise your right hand, please? Do you solemnly swear, affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Barnes, I know you're under a sentence there, but are you subject to any probation or parole anywhere?
No, sir.
All right, and as we've indicated, you would be entering a plea to use of narcotics. The felony and the habitual offender enhancements would be dismissed, which means the maximum penalty you could face would be up to 1 year in jail on this charge. Do you understand that?
Yes, sir.
With that in mind, what's your plea to that charge today?
Guilty, sir.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Threaten you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates that this happened back on March 26th of 2025. Is that the correct date?
Yes, sir.
At that time, were you present here in Kalkaska County?
Yes, sir.
And while you were here in Kalkaska County, did you have possession of some hydrocodone?
Yes, sir.
Did you have any legal right to have that or a prescription to have that for yourself?
No, sir.
Did you know that you had that in your possession?
Yes.
Mr. Ziegler, are the people satisfied with the basis?
Yes, sir.
Mr. Travis?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Barnes, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We want to, Mr. Ziegler, you're going to be asking for any kind of jail time or consecutive sentencing?
No, Your Honor,
Okay, do you have any objection to going forward with sentencing today then?
I do not.
Mr. Travis, is that something you want to talk to your client about? How did you want to?
No, Your Honor, I think we would ask to go forward with sentencing today.
All right,
Yes,
Mr. Barnes, you have any objection to going forward with sentencing today?
No, sir.
Okay. Mr. Ziegler, anything on behalf of the people for allocution?
Your Honor, it's a use of a controlled substance. Mr. Barnes is under sentence in the other county, Charlevoix, for a year, and I think he had only 6 days credit, so he's going to be there for an appreciable period of time. I don't have in front of me what his jail credit would be, but and Mr. Travis has represented that he's been in there for a month or two. I would just ask the court to sentence him to time served, and with the knowledge that he will be under sentence for the next year in Charlevoix County, regardless of what this court does.
Okay.
Your Honor, I would echo that similarly. I believe he came in to I've got appointment paperwork indicating 6/27. I know Your Honor was good enough to give him a PR bond in this case, I think back in September, but he's been incarcerated since he was picked up on this. So he's probably got close to 3 months of credit in Kalkaska, and then more time since then that he's not been let out. And then, yes, as Mr. Ziegler indicated, I think he was sentenced on October 6th to a year in Charlevoix with only 6 days of jail credit. So I would ask the court similarly to enter a time served sentence. He does actually have in a minimum 2 months plus time served in Kalkaska County, and he's been incarcerated since June.
Okay, I have it at 71 days.
I would not disagree with that. That sounds appropriate.
Okay. Mr. Barnes, anything that you wanted to say today?
No, sir.
All right, based on the circumstances, I do think a time served sentence is appropriate, given the nature of the plea in this case, which involves just use of a substance, as well as your current sentence there in Charlevoix County. So the court is going to sentence you here in Kalkaska County to 71 days with credit for 71 days served. The court is going to impose court costs of $325, attorney fees of $350, a $50 state cost, and a $75 crime victims assessment based on the misdemeanor charge. You do have the ability to appeal this sentence, Mr. Barnes. There are no written appellate rights because this is a misdemeanor. But if you wanted to appeal this sentence, you would have to file the appropriate paperwork within the next 21 days. If you had further questions about that, you would be able to talk to Mr. Travis about that. Otherwise, that sentence will be served concurrent with your sentence there in Charlevoix County. Do you have any questions at all, Mr. Barnes?
No, sir.
Okay. Anything further, Mr. Travis?
Nothing further, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay. Thank you, Mr. Barnes. That's all for today. The court's going to disconnect at this time.
Thank you.
And then People versus Taylor, case number 255106. Have you had any contact with Mr. Taylor?
I have, Your Honor. Apparently he was not aware that he had court today. He is on his way here. We'll probably be here about 12:30. I don't know if Your Honor would let us do that in your afternoon docket, but he will be here.
We could, do that at 1:45. Is that
That's fine.
available, Mr.? Okay.
I'll be available.
Okay, so we'll recall that case at 1:45. If Mr. Taylor's not present at that time, then the court will issue a bench warrant for his arrest, so. Okay, we'll be in recess until 1:30. Hey, Terry. I don't want to open the doors until it's time for those hearings.
Okay, I was gonna tell him what's going on, Mr. Taylor's up.
Oh, yeah, okay, perfect, thank you. Thank you. It's just hard to do the video ones when people are coming in and out. Okay. All right, Mr. O'Meara, are you able to hear me okay?
I am. Can you hear me, Your Honor?
I can, thank you.
Wonderful.
All right. So we'll go on the record. This is Dan Woods Properties versus Dobson, file number 20-13517. Mr. O'Meara, if you can put your appearance on the record.
Good afternoon, Your Honor. Sean O'Meara on behalf of Mr. Dan Stomber and plaintiffs. Mr. Stomber, can you please unmute yourself and state your name for the record?
All right, hold on there. We're working on it. Okay, can you hear me? Daniel Stomber.
All right, thank you. We're on the record today, excuse me, for purposes of entry of a default judgment. Default was entered against the defendant in this case back in September. Because the original complaint was not for a sum certain, the court requested counsel to set this for a default judgment hearing so the court could take evidence to establish the amount of the judgment. This hearing was properly noticed, was set for 1:30. It's now 1:35 by my clock, and no one has appeared on behalf of the other side. The court would note that no one also appeared at the September hearing that resulted in the default. Mr. O'Meara, I did have an opportunity to review your motion, the supporting affidavit, and the proposed judgment. I don't know that it's necessary to take detailed testimony from your client today. I guess what I would like to do is just put him under oath and then just ask him some questions about the affidavit itself. But I think the affidavit sets forth the basis for the amount of damages. But as we all know, sometimes counsel on behalf of their client drafts an affidavit. I want to make sure that Mr. Stomber under oath will testify to all of those amounts. So I'm gonna do that kind of questioning here just to establish what I want to know, and then if Mr. O'Meara, if there are further questions you want to ask, we can do that. Okay.
Thank you, Your Honor.
All right. So Mr. Stomber, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand. So Mr. Stomber, I specifically want to ask you about an affidavit that you signed, and in particular, it looks like it was signed back on November 10th of 2025. Do you recall signing that affidavit?
Yes, Your Honor.
Okay. And prior to signing that affidavit, did you go through, there are 18 individual paragraphs that set forth the basis for your claim damages in this case. Did you actually go through that affidavit and review those numbers?
Yes, Your Honor.
Okay. And to your knowledge, are all of those figures true and accurate?
Yes, Your Honor.
Okay. All right, thank you. And then specifically, I wanted to ask you about paragraph 16, and I know you may not have this in front of you, but it references the amount of attorney fees. And I just want to confirm with you that the amount listed there is the amount that you've actually paid, or is that just the amount that was billed? Because sometimes the amount billed is vastly different from what the client actually pays.
No,
So can you
that's the
answer that
amount
question?
paid. That's the amount paid
Oh.
as of the time of me signing that.
Okay. All right, thank you. So those are all the questions I had. Mr. O'Mara, did you have any questions for your client?
I don't, Your Honor. I think the affidavit establishes that you have evidence to support the damages.
Okay. All right, so based on Mr. Stomber's testimony before the court here today, affirming the testimony he gave via affidavit back in November, the court will grant the default judgment in the amount requested. And Mr. O'Mara, you submitted that proposed judgment. I'm going to sign that. And then you can just contact the clerk's office to make arrangements to get copies for your records, okay?
Appreciate it. Thank you. I hope you have a wonderful Christmas and holiday season.
All right, thank you. You as well. And you're both free to disconnect at this time.
Thank you, Your Honor.
All right, counsel, are you able to hear me okay?
I am, Your Honor.
Okay, we'll go on the record in Tuttle versus Kalkaska County Road Commission. This is file number 2514686. Counsel, if you can just put your appearance on, please.
Of course. Good afternoon, Your Honor. Adam Tuntis on behalf of the defendant.
All right, this was set for a status conference today at 1:30. It's now 1:40 by my clock. I don't see Mr. Tuttle in the Zoom waiting room. I suspect, I know we have another motion for summary disposition set for next month. I suspect maybe he was confused and just thought that this hearing would be taken down, which was what I was going to do anyway. There's no point in having a status conference with a motion like that pending. So my view would be just to adjourn today and proceed as scheduled next month.
That's fine, Your Honor.
Okay, you don't have any objection to that?
I don't have any objection.
Okay. All right. Thank you. I appreciate your appearance here in court today, and you're free to disconnect at this time.
Of course. Have a wonderful holiday.
Thank you. Okay. Do we have everybody on Mr. Taylor's case?
Yes.
Okay. I'm ready to go if you want to let them in. Thanks for keeping them out for now.
Yeah.
Oh, there it is. It is on the schedule. Okay, Mr. Travis, if you'd like to come forward, Mr. Taylor. Wait till Mr. Sigler.
Anybody besides Smith, we can get to ASAP.
Can you give Mr. Ziegler a call?
Oh, sure, for sure. He's on his way.
Thank you. We're on the record now in People versus Rodney Taylor. This is file number 5106. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people.
Kyle Travis on behalf of-
Thank you. This is the date set for sentencing in this matter. Mr. Taylor, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
I have, Your Honor.
Mr. Travis, are there any additions, deletions, or corrections that need to be made to that report?
No, I will.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, I would largely ask the court to adopt the recommendation of set probation. I think it's a good opportunity for Mr. Taylor. I think it's appropriate under the circumstances of the case. So I would just ask the court to adopt the recommendation.
Thank you, Mr. Travis.
Thank you, Your Honor. I similarly would ask that the court to adopt the recommendations as noted in the PSI. Mr. Taylor, in somewhat recent history, not a young person got involved with methamphetamine, but seems to have the right attitude that he's using this as an opportunity to get away from something that he saw is not good for himself, and wants to move forward and complete the terms here and not involve methamphetamine in his life as it has started to creep in the last couple of years. Thank you.
Thank you, Mr. Taylor. Anything you wanted to say today?
Sorry for being late, Your Honor, and thank you for your time.
Yeah, so, you know, we're gonna place you on probation for a period of time here. So being late to court isn't a great start to that.
Right,
So hope
I
you're-
understand.
I hope you're gonna take it seriously,
No, I will.
because there's gonna be a number of consequences if you don't. Number one, the court is gonna place you on probation pursuant to that 7411 statute, which means that if you successfully completed it, then this would not go on your public record.
Okay.
And then I'm gonna hold some jail time in abeyance. So again, if you successfully complete the probation, you would never have to serve that jail. If you have problems on probation though, then I can impose any or all of that jail time immediately.
Okay.
So, you know, there's some good motivators there for you to comply, and if you don't, then there's some consequences. I think you're a good candidate for it. Aside from being late today, I hope that you do successfully complete it, because there are some benefits to it.
Yes, sir.
From a legal standpoint, aside from the fact that just staying clean is a better way to live.
Exactly.
You're gonna
Yes.
be more productive and enjoy your life more, so it's better for you.
Right.
So I'm gonna follow the recommendation. The court is gonna place you on probation for a period of 12 months pursuant to 7411. I'm gonna adopt as the conditions of your probation all the terms and conditions that are listed in this report. Your agent's gonna go through all of those with you. It's very important that you understand those conditions. So if you have questions, you need to make sure that you're clear about it.
Okay.
I am going to impose 90 days in the Kalkaska County Jail. You do have credit for 2 days served. I'm going to hold that time in abeyance to be served at the discretion of the court. Crime victims assessment of $130, court costs of $325, attorney fees of $350, the $68 state cost, and a supervision fee while you're on probation of $30 per month. Because this is pursuant to 7411, there are no appellate rights at this time. And I am going to ask you to go across the way there and meet with the probation department following court today. They're going to go through all those conditions of probation with you. And otherwise, just make sure you stay in touch with your probation agent. Do you have any questions?
No.
All right. Good luck to you going forward.
Great, thank you, Your Honor, appreciate it.
Thank you.
Whoever's joining us on the phone with the last 4 digits, 5445, can you tell me your name, please? Sir? Your microphone is not connected. I can't hear what you're saying. Yeah, you're not muted. I think just whatever device you're signing in on doesn't have the microphone connected. So Miss Howell, is that your client, Mr. Ayat?
Yes, Your
You see
Honor.
him on? It is, okay, great. He's having some issues, I think, navigating the Zoom app and the microphone, because we're not been able to speak with him. So I'm not sure how you want to proceed.
I think he's unmuted right now. Joe, can you speak into the?
Yeah, the
Okay,
problem
we can't
isn't,
hear you.
yeah, he's been unmuted. The problem is I think his microphone's not connected, so.
Joe, do you have a different way of logging into the Zoom, maybe possibly off of your phone? Sorry about that, Your Honor.
Oh, that's okay.
This worked last time that we were on a Zoom.
Yeah, I was gonna say, I don't think we've had issues in the
Yeah.
past, but.
Okay, he's calling
Maybe,
me.
yeah, why don't you, unmute you so you can talk to him?
Yeah, Your Honor, can you hear him?
No.
He's bringing in assistance, Your Honor. I apologize to the court and to Miss Ashioni Broad and Miss Ayat. we're gonna get through this technical challenge in a minute.
Okay, no problem.
Vivian, he may just be able to call in too versus the Zoom.
Yeah, that's what I was about to tell him to do if he can't figure it out. Judge, is there a number that he can call in?
Yeah, just he would use the same Zoom instructions. He would just be by audio through his phone as opposed to video through a device or.
Let me email him the notice again, because I know he has it, but I don't want him to have to look for it. So I can try to give this to him. I think we created the notice, Your Honor, and we didn't have like the phone number, just the Zoom ID.
Okay. There's somebody joining on an iPhone now. Is he connecting a different way?
I think so. I think he's trying to. I'm going to try to text him and see, are you connecting via iPhone?
Okay. Ma'am, on the iPhone, can you tell me your name, please?
Steve Van Wagner.
Ms. Van Wagner. Okay, we're taking care of one hearing before yours, so I'm just going to put you on hold for just a couple minutes. Okay, hello. Oops. Mr. Ayad, are you there?
Judge, can you hear him?
No.
He cannot hear you. Can you just try calling? I think there's a phone number that you can use. I'm going to find out what that number is. Hold on one second. Your Honor, do we know what the number is that he can utilize to call in? Because I think at this point, that's the only way to do it. I apologize to the court.
Yeah. Yep. Okay. So he needs to call 646 876 9923.
9923. If you call that number, then we'll be all set.
Well, he'll need to enter the meeting ID like
You
he
have
did
to enter the
sign.
meeting ID off the notice. Okay? All right, thanks. Bye. Sorry about that, Judge. Thank you for allowing me to use the phone.
That's okay. I think we all want to get this one done today, so.
I think Mercury's in retrograde still, maybe. I don't know. Technology's fun, isn't it?
It's great when it works.
It is. Did you guys get more snow up there?
I think we're getting just, from now until March, just a constant stream of snow. Just depends on whether it's a little bit or a lot each day.
Yeah, we got about 4.5 inches here. Everybody thought we were gonna get 7 inches, but, you know, down in Detroit area, so we're, about only 4 inches, but it's still
It's enough
like,
to have to
ooh,
plow.
yes, exactly.
Okay, I think this might be him. Mr. Ayat, are you there?
Yes, this is Joe.
Okay, great. Excellent. Okay, so we'll go on the record now in Ayat versus Ayat. This is file number 2414662. If I could have both counsel put your appearances on.
Good afternoon, Your Honor. Vivian Atisha Howell on behalf of Joseph Ayat, the plaintiff.
Jordan Ashland Broad on behalf of Lindsay Ayat, the defendant who is present via Zoom.
All right, we have this set for a final hearing to enter a judgment of divorce. Ms. Howell, is that how you wanted to proceed today?
Yes, Your Honor, and I believe the court has copies of the judgment of divorce that the parties have signed, which lay out the provisions of the settlement that we've been able to reach in this matter, which was signed, I believe, on November 25th was the final execution of the plaintiff, and the defendant had signed on November 17th.
Okay. All right. So I'm going to, Miss Ayat, if you can turn on your camera and microphone, please.
Can you hear me?
I can, yep. So Mr. and Miss Ayat, if you both can raise your right hands and let me know once they're raised.
Raised.
I'm raised.
You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes, Your Honor.
Thank you. You can lower your hand. As a plaintiff, Ms. Howell, I'm going to have you proceed with your client first, please.
Thank you, Your Honor. Your Honor, would you like me to just voir dire my client in regards to the statutory requirements, and then do you want me to state some of the provisions of the settlement on the record?
I don't necessarily need all the provisions of the settlement since we have both parties' signatures on the judgment. So really, yeah, just the statutory proofs.
Perfect. Thank you, Your Honor.
Unless there are issues that you want to make clear for the record as to the settlement.
I do not believe so. I think we worked on this diligently and for quite some time, but opposing counsel and I worked really well on trying to get this done and finalized. So we just want to take the proofs today and have the court sign the judgment and send us back copies if that's okay.
All right, very good. Yeah, so go ahead with just the statutory proofs then.
Thank you, Your Honor. Mr. Ayat, can you please state your full name for the record?
Joseph Michael Ayat.
Okay, and at the time that you filed your complaint for divorce, had you been a resident of the state of Michigan for 180 days?
Yes.
And were you a resident of the county of Kalkaska for 10 days immediately prior to the filing of your complaint?
Yes.
And at the time that you filed your complaint, were the allegations in the complaint true?
Yes.
And are those allegations still true today?
Yes.
And is it true that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that they can be repaired?
Yes.
Okay. And if the judge did not grant you a judgment of divorce today, are there any circumstances in which you and Ms. Ayat could still live together as a married couple, as husband and wife?
No.
Okay. And is there any possibility for reconciliation?
No.
And is it correct that there are no minor children in the marriage currently?
Yes, correct.
Okay. And to your knowledge, is Ms. Ayat pregnant?
No.
Okay. And you signed a judgment of divorce on November 25th, is that correct?
Yes.
And did you read all of the provisions in terms of the judgment of divorce?
Yes.
And do you understand all those provisions?
Yes.
And were you under any sort of duress when signing the judgment of divorce?
No.
Okay. And you signed this judgment of divorce on your own free will?
Yes.
Okay. And do you believe that the judgment of divorce and its terms are fair and equitable terms?
yes,
And you understand that if you had a right to a trial in this case, and at trial the judge could have ruled more favorably or less favorably, or a substantially similar result to the settlement that you had in this case?
say that again?
Sure. Do you understand that you had a right to trial in this case?
Yes,
Okay, and do you understand that the judge could have ruled more favorably in your favor or less favorably? Okay, and that, or he could have ruled in a manner which was substantially similar to the settlement that's in this case?
yes,
Okay, and do you want the judge to enter your judgment of divorce today?
yes,
Okay. Your Honor, I don't have anything further unless the court has anything else. Oh, I'm sorry. I did want to ask, I apologize. Mr. Ayat, as we sit here today, do you have any questions regarding your judgment of divorce or the provisions
No.
thereof? Okay.
No.
And through this point, are you satisfied with my representation of you in this matter? Okay.
yes.
That's it. That's it.
Thank you. Ms. Ashiona Brode, did you have any questions for Mr. Ayat?
I do not.
Did you wish to take any testimony from your client today?
Just a few questions, Your Honor.
Okay, go ahead and proceed, please.
Ms. Ayat, can you please state and spell your name for the record?
Lindsay Janine Ayat, Lindsay, Janine, Janine, Ayat, IOTT.
And you're the defendant in this matter, is that correct?
Pardon me?
You're the defendant in this matter, is that correct?
Yes,
Have you had a chance to review the consent judgment which was submitted to the court?
yes,
Did you voluntarily sign that?
yes,
Do you believe that the terms in the judgment are fair and equitable?
yes,
Do you understand that if Judge Mertz approves and enters a judgment that absent a demonstration of fraud, duress, mistake, or an unconscionable result, there's no turning back and the terms in the judgment are a final award?
yes,
Do you understand that you had a right to a trial in this case?
yes,
And that at the trial, the result could have been more favorable, less favorable, or substantially similar to what is currently in the judgment?
yes,
You understand that there is no spousal support awarded to either party, correct?
yes,
And that is forever barred, meaning neither you or the plaintiff can come back and seek that from the court.
yes,
At this time, are you asking the court to enter the judgment?
yes.
No further questions, Your Honor.
Thank you. Ms. Howell, did you have any questions for Ms. Ayat?
Ms. Ayat, are you currently pregnant?
No.
Okay, that's it, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. The court's reviewed the proposed consent judgment, finds that it's generally equitable and contains all the provisions required by statute. I've signed that judgment with today's date. Ms. Howell, anything else that we need to address for the record today?
Nothing, Your Honor. We just thank you for your time and your patience this afternoon. We appreciate it.
All right, thank you. Ms. Ashioni Brode, did you have anything further?
No, I do not. Thank you, Your Honor.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you, Your Honor.
Thank you. Thank you. Thanks.
Okay, Ms. Van Wagner, if you can unmute and turn your camera on, please. Here we go. Okay, we'll go on the record in Van Wagner versus Van Wagner. This is file number 2514867. The record should reflect that both parties are present today by Zoom video. I have this set for entry of a judgment of divorce today. Ms. Van Wagner, is that how you wanted to proceed?
Yes.
And Mr. Van Wagner, is that how you wanted to proceed as well?
Yes.
Okay, I'm going to place both of you under oath, and then I've got some questions for each of you. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would please both raise your right hands. You both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can both lower your hands. Ms. Van Wagner, as the plaintiff, my questions are going to start with you. You filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint? Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this divorce, you will not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Sorry, I didn't hear. Okay, thank you.
Mhm.
And it looks like in terms of personal property, that's already been divided up. Is that correct?
Yes.
And then the property on Arthur Lane in Elmira, that's going to go to Mr. Van Wagner. Is that correct?
Yes.
And you will quit claim any ownership rights that you have to that property to him?
Yeah.
Okay. Ms. Van Wagner, are there any other issues regarding the assets or debts of the marriage that need to be decided by the court?
No.
Thank you. Mr. Van Wagner, have you heard all the questions that I asked Ms. Van Wagner?
Yes, Your Honor, I have.
Did you hear all of her answers?
I have heard them.
Do you have any reason to believe that any of the answers she gave were untrue?
No, Your Honor.
Under this judgment, you also would not be receiving any alimony or spousal support. You understand that you would also be waiving that forever and you would not be able to come back later and ask the court for that.
Yes, I do.
All right. And do you agree with the statements regarding the division of assets and debts of the marriage, including the real property?
Yes, I do.
All right. Thank you. Ms. Van Wagner, are you asking to have your last name changed?
No.
Okay. All right. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. I've reviewed the judgment. It's equitable and contains all the provisions required by statute. I've signed that judgment. That means that your divorce is final as of today. Ms. Van Wagner, do you have any questions at all?
No.
Mr. Van Wagner, do you have any questions?
No, Your Honor.
Okay, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you.
Thank you.
Ma'am, can you tell me your name, please?
John Pfeiffer?
Cipher, okay. All right, we'll go on the record in Pfeiffer versus Pfeiffer. This is file number 2514891. And the record should reflect Ms. Pfeiffer's present by Zoom video. This is set for a pretrial hearing in this divorce case today. Ms. Pfeiffer, it looks like, based on the filing that Mr. Pfeiffer submitted, that he's not contesting anything with regard to the divorce. So I can set this for a final hearing. There is one more form that I'm going to need for you to submit prior to that final hearing. It's called a judgment of divorce. You can find that online or find it in the same place that you got your forms to file for divorce. So I'm going to need you to get that form. Again, it's called a judgment of divorce. I'm going to need you to submit that to the court prior to the next hearing date, and then I can finalize the divorce. Do you have any questions about that?
No, sir. Just,
Can you do that within the next 30 days?
yes.
Okay. So I will set this for a final hearing. The court will send you a notice of the date and time of that hearing, just like we did for this hearing today. It'll also be by Zoom, just like this hearing is today.
Okay, I do have a question. Do I just return this to the courthouse, county clerk then?
Yeah, that form called the judgment of divorce, you just need to
Yes.
fill it out and turn it in to the clerk.
Okay, all right.
And just make sure that you do that before that next hearing date.
Okay.
All
And
right,
you're
did you
going
have
to
any-
send me a notice as to when that is, correct?
Yes, just like we did for today's date. Yep.
Okay. All right,
Did you
thank
have
you.
any other, do you have any other questions?
Well, we,
This month,
we're here with Sean. We had a little discrepancy. We thought this was gonna be done just as a virtual phone call. And so, the next time that we get on, we just have to log into Zoom, right?
Yep, just like you did today. Exactly.
Well, we had trouble doing this because we first, a friend of hers got on his phone and got on Zoom. And she's kind of frustrated because she couldn't get on her phone, and it was just, we just weren't quite sure how we were gonna do all this, and that's why, a little confusion today. But, so next time we'll just know that we need to log into Zoom and then we'll be connected.
Yes, exactly. I mean, you guys are connected now, so whatever you did today to be on is just what you're going to want to do the next time.
Yeah. Well, we used another phone to do this. And that's,
Oh, okay.
and we were kind of concerned because it didn't have her name on this phone that we're using, but it's just a friend of hers. But we'll get it all straightened out before the next court date.
Okay. All right. Very good. That's all for today then, and you're free to disconnect.
all right, thank you.
All right, looks like we have everybody connected. So we'll go on the record in Nellis versus Munson Healthcare. This is file number 2113787. If we could just have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. John Elliott on behalf of Mr. Nellis. Your Honor, Dave Elliott.
Your Honor, Nick Artave on behalf of the Kalkaska defendants.
Your Honor, Kevin Lesperance also on behalf of the Kalkaska defendants. Mr. Artave is going to be doing the arguments today, but to the extent that we talk about the trial generally, or you want trial counsel to answer questions, I'm here.
Okay.
And Your Honor, I don't know if you heard, James Elliott's on also.
I didn't. I see him connected, so I will recognize his presence as well.
Thank you, Your Honor. I think I'm connected now.
Okay, great.
Good afternoon, Judge Mertz. This is Paul DeWahey, and I'm appearing on behalf of the Munson Healthcare defendant.
Okay. All right. Thanks, counsel, all of you for being on here. You know, I very much apologize for that prior hearing. We had an internet outage at the courthouse where I was going to do that hearing from. And I know that threw a wrench into everything. I know you were all, you know, kind of forced to be present for that hearing anyway. So I really apologize for that, for your time. Counsel, it was one of those things that couldn't be helped, but I appreciate all of your patience and forbearance in appearing here today. And again, I apologize on behalf of the court. In terms of what we have today, we got a number of motions in limine to go through, and then a kind of this trial prep conference where I've got a list of things that I want to address with all of you in terms of the trial. And then I'll take up whatever other matters you have regarding the trial. So we've got a lot to go through. I do want to say before we start with arguments on the motions that I have thoroughly gone through each of the motions and read the motions and the responses. So in terms of argument, and I'm gonna kind of put them in the order that I think from easiest maybe to most, I don't want to say difficult, but most complex anyway. But if you can just keep your arguments succinct today, that might help us move through things. So the first motion I have up is, and I believe that the Munson defendants have more or less joined in each of the Kalkaska defendants' motions, but Mr. Dwayne, to the extent you haven't, feel free to speak up. But the first motion I have, defendant's motion to exclude evidence of the criminal convictions of the two Kalkaska individual defendants. Mr. Arte, have anything that you wanted to state for argument on that?
No, Your Honor, I think it's pretty self-explanatory. You know, plaintiff's counsel elicited through their deposition of Mr. Miller and Mr. Aylesworth that they had a couple of criminal convictions. One was related to an assault arrest, and the other was related to what he described as covering up for his girlfriend for retail fraud that happened 30 years ago. I think ultimately, Your Honor, you know, aside from the relevance issues of these criminal convictions, we've highlighted that MRA 609 is really the controlling evidence rule here. And from what I saw in plaintiff's response, they didn't really address how they can get past that one. Ultimately, you know, Mr. Miller's, you know, criminal conviction was not a crime of dishonesty or anything related to a false statement. And as to Mr. Aylesworth, that conviction took place over 10 years ago. So MRE 609 precludes that evidence from coming in. So, you know, keeping that argument succinct, Your Honor, I'm happy to answer any questions you might have about that.
All right, thank you. Mr. Dwayne, anything you wanted to add to that?
I'm going to be succinct also, Judge. We've concurred in all of our co-defendants' motions, and I have nothing to add. Thank you.
Okay, thank you. Mr. Elliott?
Your Honor, we have no objection to their requesting that motion, and we don't intend to bring up the criminal offenses.
Great.
Okay. All right. Can I just ask why you responded and contested the motion?
At the time, Your Honor, we thought that there may be some relevance to the fact, not as much and I think this was in our motion, not as much of the actual convictions, but of him on the record swearing under oath that he had lied. That was the issue.
Okay. All right. So the court will grant the motion. Next motion, defendant's motion to exclude plaintiff's witnesses or to exclude non-disclosed witnesses. I don't feel like we really need a lot of argument on that. I mean, number one, plaintiff's witness lists are pretty exhaustive. I can't imagine that there's anybody that they would call who hasn't been disclosed. I don't think anybody could come up with any witnesses that haven't been disclosed in one way or the other. And I think certainly to the extent that the plaintiffs would try to call a witness that hadn't been previously disclosed, that would be something I would assume would come up during the course of trial that we would have to address at that point. But I think otherwise, I think it, kind of speaks for itself. The plaintiffs, nobody can call witnesses that haven't been disclosed unless there's a specific exception to it. So Mr. Arteev, or do you have anything further on that motion, or was there something I'm missing that you were asking for there?
Yeah, sorry, Your Honor. I think the scope of that motion has also kind of changed since we initially filed it, just through discussions with plaintiff's counsel. And just so this court's aware, we have had some good communication with plaintiff's counsel about kind of nailing down the witnesses and who's going to testify in this trial. I think we're kind of almost at the point where we're going to come up with a trial calendar as well of when witnesses are going to appear. But besides the point, Your Honor, I think the only thing that remains is, plaintiff's counsel is, subpoenaed this Kristen Kuhl. That's really the only witness I think that that we haven't deposed that they seemingly intend on having testify at trial. I don't know who she is. She seems to be, based on a Google search, someone who is an MDHHS representative related to some EMS coordinator, and I'm not quite sure what her role will be in testifying in this case, especially considering the admission of liability as to the handling of the stretcher. So I'm not sure what relevance she would have. I understand plaintiff's argument is that they've included, these witnesses amongst their witness lists in the past. There's hundreds of witnesses listed, but I think ultimately the point of the motion was that we had asked plaintiff's counsel to specifically indicate which of those hundreds are they actually planning on calling to trial. I think it's implied that they're not going to call 100 witnesses when they simultaneously also indicate that trial is only going to be 5 to 7 days, and we didn't get a clear response. The other issue that's come up, and this really came up only yesterday, Your Honor, is that plaintiff's counsel, I think looks like they filed an amended witness list, or at least notified us that they plan on calling defense counsel as potential witnesses in trial, specifically myself, Mr. Lesperance, Mr. Dwahey, and former counsel for Kalkaska, Mr. Dost. I really don't know what the purpose of that would be. They indicated in the email along with that notification that it was because we had signed discovery responses previously, and they want to have the opportunity to, I guess, examine us on those discovery responses. But I guess to the extent of our motion and the relevance of, these witnesses, I guess I'd ask the court to, preclude any such, ability to call defense counsel as witnesses. I'm not sure there's a basis for that. I'm not sure what the purpose of that is. And it's kind of distracting and I think unnecessary ultimately.
Your Honor, I'd like to respond to this motion. In reference to our witness list, we never had 100 individuals listed. I provided a very specific witness list. Ms. Sporer is the representative, according to the defense, that will be appearing on behalf of the Kalkaska defendants. Ms. Glasser is the witness representative that will be appearing on behalf of the Munson defendants, according to the defense counsel. So I have listed both of those individuals. Both attorneys for both sets of defendants have objected and said they do not want them to testify. My response to them, and we've had discussions on this, so this didn't just come up yesterday, by the way, Your Honor.
Well, can I stop you for 1 second, Mr. Elliott? I just need to stop you for a second because both the people you've just mentioned, Mr. Arteyev didn't mention either of those individuals, so I'm not sure where we're going with that.
Well, I'm telling you why the attorneys have been. Well, Mr. Lesference has always been always on it because he signed the majority of the discovery requests, and I've asked them before to have a representative available and to sign the documents. I brought it to Your Honor's attention once during a motion, but they did not have to the discovery requests individuals sign them from the corporations. They themselves sign them. All I want to do, and I've offered it twice, I put in writing to them, I don't necessarily want to call them as witnesses, but if they're not going to allow me to call the other two representatives that they designated that will be there on behalf of the defendants, someone here must be available to answer to the discovery requests. So these attorneys that were just referenced by name, they're the ones that actually signed and provided the answers. No defendants, Your Honor. They signed as representatives and agents of the defendants, not as attorneys. Again, I don't want to call them. I'd prefer to call the two representatives, and those are the ones that I've notified defense counsel as to my intention. And again, both of them indicated they would not be providing them for that purpose. So who do I call? They provided, for 4 years, they provided answers to discovery, interrogatories. Now they have to answer to them if there's any questions pertaining to them. There has to be someone. And as I said, I don't care who it is. I told them in 2 different letters, just give me someone that can answer to their clients' discovery responses.
Well, I mean, all right. All right, Mr. Arteyev, what's your response to that?
Your Honor, I will say that I looked over our discovery responses and I kind of anticipated that this would be brought up, but we did have Ms. Sporer sign any interrogatories that were directed towards Kalkaska as an entity. We even had them notarized, which I don't think is even required under the court rules, but we did do that in several supplemental responses. But regardless, Your Honor, ultimately, I guess I guess it would help to know what exactly plaintiff's counsel wants to ask these, what he wants to ask these representatives, because ultimately the issues at trial are pretty narrow at this point. The admission of liability indicates they don't need to bring up any evidence about the handling of the stretcher. There's damages, there's causation. We've admitted to the vicarious liability claim as to Kalkaska. And then, I guess the only other issue would be the negligence of Kent Aylesworth, damages and causation for his alleged negligence. So I guess I'm curious what is going to be required of the representatives to testify about. From what I also understand, those discovery requests that were directed towards the corporation, a lot of those were essentially kind of, general legal questions where they're asking about like disclosure of witnesses and, who they're going to call and testify to and employment issues and things like that. So again, I don't really see the relevance of what they're going to have to testify about, but I guess if plaintiff's counsel has something specific that they intend on calling them about and examining them on, then that's different, and we can talk about that. But I think just generally saying these people might get called, I'm not sure there's a basis for that.
Your Honor, I have approximately 5 to 6 sets of discovery for each defendant. They're right here in front of me. Every one of them signed by an attorney, with the exception of Miss Four, signed one, and Miss Rachel Rowe, another attorney that's in-house for months, and signed the other one. Other than that, the defense attorney sitting there and the one that's not sitting there, all signed as representatives and agents. I knew this was a problem from the get-go. I addressed it with them. And now he wants me to tell him every question I'm going to ask. I don't know. I didn't know until a few days ago they were going to partially admit liability. I may have no questions of them. I may have several questions, which I would now have, depending on what happens between now and if they give us any additional admissions between now and the time of the trial. But when he said Miss Forrest signed the interrogatories, that's correct. She signed one interrogatory, as I indicated, and Miss Rachel Rowe signed another set of interrogatories. Very small. I think the one had 3 interrogatories to it. So there's substantial information out there. The attorneys never, it's my belief, the attorneys never thought this case would get to trial. They've told me from the get-go that it was going to be dismissed by the Court of Appeals by Your Honor. I think 40 years, I've never had attorneys sign discovery. And they signed every single set of it. I have to have someone to ask questions. And I'm not, like I said, I'm not trying to be hard-nosed and say, I've got to have the attorney that signed it. I'll take anyone from Munson or Kalkaska. I don't care who it is. Just give me a representative. I asked for that before. I was told Judy Sporer and Beth Glasser are both going to be sitting there as the representatives. Someone has to verify these answers if it's relevant. I've been doing this a while. I don't plan on asking questions that aren't relevant. I'm not going to, the gentleman just brought up, well, they signed who the witnesses would be, something like that. I'm not going to ask them those questions, Your Honor. I know we have 5 days. I like to do it in 4. I'm not going to waste the court's time, my time, their time, or our client's times by asking irrelevant questions. If I have a question to ask, I believe it will be relevant. But who's going to answer it? The defendants don't get a free pass because they failed to follow the court rules. They signed as agents, they signed as representatives.
Yeah, okay, all right. Well, I really, I think maybe we're all putting the cart before the horse here, because I think to the extent that there was going to ever need to be testimony about answers in discovery requests, I mean, it would have to be relating to some specific testimony or some specific issue. So I'm just going to reserve ruling on that now. I mean, plaintiff subpoena whoever you want to subpoena. I can tell you this, I think it's highly unlikely that I'm going to allow attorneys to be called as witnesses, particularly if they're attorneys practicing in the case. So however that works out, I really don't know. I think that is going to have to be a specific situation that we'll have to deal with if it comes up. I think it's impossible for me sitting here now to come up with some kind of prospective ruling about how we might deal with that. I just will say that it would have to be an extraordinary circumstance before I'm going to have a trial attorney or attorney who's been directly involved in the preparation of this case being called as a witness to testify. So I'll just say that, but strange things happen at trial, and maybe some extraordinary circumstance will come about where that's justified by court rule or case law. I'm just saying, that sounds like something that would be really extraordinary to me in my 13 years of trying cases here. So,
Well, Your Honor, I have subpoenaed the two representatives, so they have been subpoenaed. I only did that after the attorneys told me they didn't expect them to testify. So if Your Honor enforces the subpoena, there's not going to be an issue, but there has to be someone there to answer on behalf of the defendants, and I subpoena the appropriate people.
okay, all right, well, then we'll see where we go with that if it comes up at trial. I tend to think it wouldn't be relevant in light of where we're at with the case now, but again, who knows? And I appreciate, Mr. Elliott, your position that you're not going to just chase down things that aren't relevant, because our trial time is going to be very precious. And I'm going to have a number of citizens of Kalkaska County right before Christmas who are going to be sitting here against their will. And I'm not going to be wasting their time. I can tell everybody that right now. I am very protective of my jurors and their time, and especially when it's right before Christmas on a week-long case. So I'm going to expect everybody to be getting down to what's really at issue in the case and not wasting time on collateral issues that aren't materially relevant. So I'm going to hold any ruling on that motion in abeyance pending what happens at trial. The next motion that I have is the defendant's motion to preclude reference to the timing of the defendant's admission of a breach. And I know the plaintiffs have raised a lot of issues in their response regarding that admission and the breadth of that admission and the sufficiency of that admission and so forth. But the motion really relates to evidence regarding the timing of it. And so I'm just going to go straight to plaintiff's counsel and ask what would the relevance be of when those admissions were made, not what they are or how broad they are or extensive or what they mean, but that the motion really relates to bringing in evidence about when it happened. So what's plaintiff's response to that?
And Your Honor, I guess I was not 100% clear. I know they titled their motion timing as well as they titled some of their other motions different from what was actually argued. I don't know what sort of argument would be about the timing, but there's definitely, so my thought was this was a very broad motion they wrote. I think they were trying, I took it, and what I was responding to is I don't want to be handcuffed that I can't address the fact that they said no, they didn't do it before. The fact that they in their request for admission said they didn't even have any responsibility at all for him, that they didn't even have him under his care. I don't want to argue about timing. As far as I'm concerned, I don't know if, that there has, at the time I wrote this response, there had not been any admission. There was a letter that there may be an admission, and now there's been a document filed right before the last motion that seems to be a partial admission. So I'm not, I guess I wasn't 100% clear either. I'm not arguing that I'm going to say, hey, you didn't admit liability till, December 2nd or whatever the date that they argue is an admission. But I don't believe that we get to be hamstringed from addressing all the times that they denied facts. This is a factual argument. So that's my argument. And I thought that was in my brief. So that's what I tried to come across. I don't see anywhere that there wasn't an admission at the time that they wrote this. I still don't think there's a sufficient admission. But either way, I'm not going to argue about what time they admitted it.
All right, so I guess what I took, and maybe Mr. Arteav, you can correct me if I'm wrong. What I took from the motion was that you're trying to preclude the plaintiffs from arguing that, hey, they waited till the last minute. That means you should award more damages because my client, the defendants, delayed making this admission. I mean, is that your argument?
That's exactly correct, Your Honor. That's exactly what we were asking.
All right, so Mr. Elliott, what's your
That's not an
response?
argument we would make, Your Honor. But again, the facts will reveal that they had denied it numerous times. I'm not going to make any argument about the time, but I am going to ask them, you knew this, you knew these facts here. Why did you deny that you had control of this man? I'm not going to bring up that they're now saying they didn't.
I guess
So
I
I
think.
don't know if that's clear, Your Honor, but I don't think that argument does get to timing.
Mr. Artea?
I mean, I guess I fail to see the difference if plaintiff's counsel is planning on, bringing up date stamps and saying, oh, look at this discovery response here, and you weren't admitting it at this time, but then you admitted it later, then how is that not relevant to timing?
So see, Your Honor, that is exactly the argument I thought they were making. They were trying to preclude every contradict throughout their motions. They title them certain ways. They are generally trying to preclude every inconsistency that their clients have made, every falsification, every inconsistent statement or contradictory piece of evidence. And that's what they're trying to do. And that's what I'm arguing against. It's not an argument that I want to talk about the timing.
All right, so that's not, but that's not an inconsistency, okay? That's a legal position. Denying liability throughout the case is a legal position. That's not it's not a factual inconsistency. And so none of the individual defendants here, they didn't have anything to do with when the decision was made to concede liability. I mean, that's a strategic legal decision made by the legal team. And I don't think that you can cross-examine witnesses on a strategic legal decision that was made by the lawyers. I mean, that's a problem, and that has nothing to do with credibility, because again, that the individual defendants didn't have anything to do with the decision to admit liability or when. They're following the advice of their attorneys. So I disagree, Mr. Elliott, that it's an inconsistency, a factual inconsistency. So I agree with Mr. Artea to the extent that you're gonna try and cross-examine individual witnesses on initially denying liability and then later conceding liability for purposes of trial. To me, that's something completely different than cross-examining somebody on, well, you testified earlier that X happened at X point, and now here at trial, you're testifying to something different. I mean, to me, that's cross-examining or calling into question credibility. So the court is going to grant the defendant's motion because, again, I agree with Mr. Artea, that's the same thing as is calling out the timing. The only relevance of that, because it doesn't go to credibility, as I said, the only relevance of that is to make an argument that, hey, the defendants denied this and now they're admitting it, and so you should award more damages on that basis. And that's not permissible. So I'm going to grant the defendant's motion on that.
Your Honor, may I ask a point of clarification on this? Because I'm not sure, and it's going to make a huge difference on the way we prepare and possibly the witnesses we have. I understand the timing. We never asked, as I recall, any individuals anything about liability. We asked them what they did. As an example, they testified and they wrote in the report that everyone relied upon, all the doctors, that he never hit his head. We're positive he didn't hit his head, and we're positive he didn't hit his body. That all goes to not only credibility, it goes to the amount of damages, because if he falls on his head and he falls on his body and they say he didn't, that's a falsification. That has nothing to do with admitting or denying liability. Those are the facts we're talking about examining these witnesses on. Clearly not what time they did it or whether or not they admitted liability. But the defendants are, and I'm not so sure it is just a legal decision filing that partial liability admission, but in reference to the facts and what they testified they did and the way it impacted our clients, I think that goes to credibility, it goes to negligence, and it goes to damages, because they're not admitting full liability. They're taking a very small piece for two defendants and admitting it. So if it's
so what you just said is different than what the other Mr. Elliott said. So there's a distinction there to me. And by the way, I need you guys to I can't double team arguments. I can't respond to two lawyers on one motion. So I need you guys to decide who's going to argue which one. Because otherwise I'm not here to try and parse out arguments from two different lawyers on one motion. So
My apologies. Can I finish this one then, Your Honor?
I've ruled on it. I'm done with it. To the extent we need clarification, sometimes I guess it's going to depend on the question that's asked at trial. If you're asking about what James Elliott just said, which is, you testified that he didn't hit his head, but here's evidence that he did. How do you explain that? That's something different than saying you denied liability all through this case and now you're admitting it. Why is that? I mean, to me, that is completely irrelevant and impermissible. So
agreed.
I'm not going to tell you guys how to craft your questions, but the way John Elliott stated it to me, that's the way it sounded like that's how it was going to be presented. And I don't think that's a factual inconsistency. So my ruling is what it is.
Thank you.
Parties will just have to be cognizant of that when you're asking your questions. And if it's improper, I fully expect defendants to object and I'll either sustain or overrule the objection as we're going through testimony.
Thank you.
Okay, next one, defendant's motion precluding the plaintiffs from arguing about or referencing dismissed allegations. Mr. Arteav, correct me if I'm wrong, but it sounds like what you're asking the court to preclude are arguments or testimony that there was some kind of deliberate misconduct, cover up, falsified medical records, falsified videos, what sounds like malfeasance or intentional conduct. Is that a fair statement? And because those all relate to claims that have been dismissed.
Correct. Well, in part, Your Honor, I think ultimately we want to, additionally, we talk about some of the evidence and testimony that's been elicited from Mrs. Nellis and Mr. Aylesworth and Miss Main specifically regarding allegations, I think, that were specifically directed towards these fraud and fraud and false representation claims that were dismissed in this case. But as to those other issues, I think ultimately, Your Honor, the subsequent discovery that was attempted by plaintiff's counsel regarding specifically, I think, the surveillance video footage that they consistently try and say that we, edited or, made different in some sort of way. That was, I think, already kind of part of some of the motions to compel that were ruled upon a year ago or so. And basically, I don't think there was much evidence from plaintiff's counsel to indicate that any of those allegations were true. And I guess specifically this motion becomes more relevant because they've included in their proposed jury instructions, and I guess this is more of an issue of deciding what the proper jury instructions will be, but they've included a proposed instruction regarding spoliation of evidence, again claiming that we had edited the surveillance video. We've been more than transparent with plaintiff about these issues. We allowed them to depose Mr. Hilmert, who is this security person who was in charge of the cameras. I don't think there was anything in his testimony that supported their allegations and claims. So I think, Your Honor, if they continue to go down this route, which really doesn't have any bearing on any of the remaining issues, I think ultimately it's just irrelevant. It's a waste of time, and it's just going to distract the jury from the remaining issues in this case.
All right, thank you. Which Mr. Elliott would like to argue this one?
I will, Your Honor.
Okay, thank you.
Your Honor, so the defendants on their brief said that, and you said it, I think, very succinctly, the four things they're trying to avoid testimony regarding. And again, my response is because I don't know exactly what they are talking about. But Your Honor dismissed certain claims legal claims from this matter because of governmental immunity. It doesn't mean the facts are not relevant to the remaining negligence claims or to credibility of witnesses. It is a fact that Diane Nellis testified that Kent Ellsworth never called her and told her what happened to Ed. It is a fact that she testified that he told her at first that it was just a light fall in a snowbank. It's a fact that Kent Ellsworth said he called her and then was not able to produce any records to show that. These are facts. They're relevant facts that go towards one, negligence, because these are not things that a reasonable person would do. It's nothing to do with a medical decision. And two, it has to do with credibility, and it's very relevant to credibility, which is, at the heart of all testimony. The next one is testimony insinuating or arguing that medical records were intentionally altered or changed. This I'm not 100% sure of what they are referencing. I know that one of the Michael Bryan altered, as the records show, his report. He did it over a month later. He did it twice, yet he never showed what was originally there as is required. These are facts that a jury, I think, gets to decide. These facts could go towards damages. They could go towards credibility, clearly, and also to negligence, because that's not a reasonable thing to do. These are not arguments about claims. They are arguments about facts that are very relevant to the remaining claim and to whether or not a jury is going to believe the witnesses sitting in front of them. As far as the video, those last two, and we addressed it in the motion. The video, Your Honor, ruled on a motion to compel that, as far as you could tell, they gave us what they had. This was years ago that this happened. It doesn't mean that we don't get to argue and make a reference to what happened to the videos. What we did find out is that there were two separate videos. What we did find out is that for some reason the video cut before the ambulance drives away. So we don't get to see if that step was actually down that it allegedly was. There's another video in the camera in the line of sight that would have caught the full incident. It would have showed exactly if his head hit the ground and how hard it hit. Yet that video was not produced. It doesn't mean they had it still. It doesn't mean that anyone maliciously got rid of it, but somehow these videos were not produced. They were not maintained, and a jury gets to decide, I think, and that's why that instruction was in there as a proposed instruction. If the facts reveal it, gets to decide what weight to put on that and whether or not they would believe that evidence may have been favorable to the plaintiff if it had been preserved. Those are the arguments, Your Honor. Those are the arguments that I think it's set forth in our brief.
Your Honor, may I just briefly respond to that?
Yeah.
I just want to direct the court to the actual pleading that the plaintiffs had regarding their negligence claim. It alleges that defendants breached their duty of reasonable care by failing to transport plaintiff Edward Nellis in a safe, controlled manner, failing to secure the gurney, and allowing him to sustain life-altering injuries. I don't know what anything that plaintiff's counsel just referenced has to do with that remaining claim of ordinary negligence. And so, I'm not sure what credibility has to do with that remaining claim of ordinary negligence, how it has anything to do with damages, how it has anything to do with causation. So ultimately, I think the point of this motion is just to keep the trial focused on the remaining issue that the jury needs to decide.
All right. Yeah, so, the court did dismiss those claims. I think, if there wasn't, and I disagree that all of those were dismissed on governmental immunity grounds. It's my recollection that the court dismissed a number of those on C10 grounds, that there wasn't sufficient evidence to show that. And if there wasn't sufficient evidence for it to survive summary disposition, then there isn't sufficient evidence to put it before a jury. But aside from that, I think the bigger problem is the relevance of it, and whether or not the question about the video camera, the question about falsifying allegedly medical records, the issue of who called Miss Nellis and what they said, maybe that becomes relevant somehow during the trial, but it certainly isn't relevant to the claim, as Mr. Arteev stated, which is negligence related to dropping Mr. Nellis from the stretcher. And the negligence claim isn't whether or not Mr. Ellsworth made a call to Miss Nellis and when and what he told her. None of that relates to whether they were negligent in dropping Mr. Nellis and what damages resulted from that. And so, you know, certainly the plaintiff is free to impeach and to call in to question the credibility of any witness. That's always fair game. Credibility is an important consideration, but credibility as to what is the question. And I think impeaching a witness or pointing out inconsistencies in witness testimony is very different from arguing to a jury that there was some type of deliberate cover-up or videos were hidden or there was some type of deliberate malfeasance, especially when the court's already dismissed those claims that were brought. In my view, the only purpose for bringing that in front of a jury is to appeal to the passion or prejudice of the jury and say, yeah, they were negligent, but then look at all this other stuff they did. So you should award more damages because not only were they negligent, but they covered up this video and, you know, they lied in a phone call to the plaintiff's wife. None of that really goes to the main issue about whether they were negligent and if they were, whether that caused the injuries and what the value of those injuries are. So again, in my view, the only purpose for those arguments is to appeal to the passion or prejudice of the jury, which is not permissible. They relate to claims that were dismissed. Again, I think to some degree, there's a fine line between impeaching testimony, you know, calling into question credibility of testimony, and insinuating or accusing any or all of the defendants of engaging in malfeasance over and above ordinary negligence, where clearly that's not a claim. The jury can't award damages based on that, and they can only award damages based on ordinary negligence related to the claim as pled. So the court is going to grant the motion of the defendants on that issue. The next one we have is defendant's motion regarding opinion testimony as to causation. And what I viewed this, and again, Mr. Arteev, you can correct me if I'm wrong, it relates specifically to Miss Nellis and to the physical therapist about Miss Dawson. I think it's Dawson, can't read my own handwriting. About the delay and the effect of that delay on the damages regarding Mr. Nellis in his stroke. So, but feel free to flesh that out if you need to.
No, Your Honor, I think you've hit the nail on the head. This is part of our argument that we made in our MSD related to causation regarding the stroke related damages, but ultimately the court didn't rule on that particular issue on whether their testimony on these particular opinions are relevant. I think, you know, we cite to this Infinity physical therapy case, and Miss Dawson is an occupational therapist, just to clarify, not a physical therapist, but their definitions statutorily are very similar in that specifically the MCL 333.18301E basically states that occupational therapist doesn't include the practice of osteopathic medicine, medical diagnosis, or treatment. And that was really, that similar definition was the basis in that Infinity physical therapy case we cite to as to why the physical therapist couldn't render opinions on causation in that particular issue. Additionally, Your Honor, you know, if MRE 702 and MCL 600-2955, Miss Dawson just simply isn't qualified to provide these opinions as well. She's not someone who's, you know, specializing in stroke. care. She's not someone who, diagnoses strokes, not someone who does anything specifically with strokes even. She testified only 15% of her patients are stroke rehabilitation patients. And so I think ultimately she's unqualified to render those opinions. And that's not to say, Your Honor, she can certainly testify about her own care and her own, things that she's done with Mr. Nellis to rehabilitate him. But, as to actually rendering opinions on whether the fall at issue had anything to do with his current day stroke damages, I don't think she's qualified to do that. As to Mrs. Nellis, obviously, she's a lay witness. She has no medical training, kind of for similar reasons as Miss Dawson. The other issue we've raised is that in her deposition testimony, she did indicate that some providers, apparently at Munson, had made these opinions, and therefore, she should be allowed to kind of present those opinions because someone at Munson had told her that that was the case. The plaintiffs argue that this is a party admission, but in that testimony, Ms. Nellis was unable to specifically identify who even told her that opinion or who even said anything about that. And regardless, I think, even given that fact that communication happened at Munson, so I'm not sure party admission necessarily applies to the Kalkaska defendants. But regardless, Your Honor, I think ultimately Ms. Nellis shouldn't be able to render those opinions. She's a lay witness. She has no education, training, experience in stroke care rehabilitation. And just as a matter of law, she shouldn't be able to provide those opinions. Thank you.
Thank you, Mr. Elliott.
Thank you, Your Honor. Your Honor, I'll start with the Ms. Dawson and the Infinity case. This was, as Mr. Artev pointed out, a significant part of their motion for summary disposition, as well as their application for leave to appeal to the Court of Appeals. It was upheld, or plaintiff's position was upheld in both of those situations. The difference and the distinction is that in the Infinity case, the physical therapist was giving opinion testimony that a medical condition caused the individual to need physical therapy. That is not what is at issue here. Dr. Raja testified that my client, Mr. Nellis, needed therapy. He testified that he needed to get into stroke therapy as soon as medically possible and that he was so ready. And that's why he sent him to Kalkaska. Ms. Dawson's testimony is completely within her lane. It is only to do with the therapy. It is only to do with the fact that she knows, and she said how she knows. She has a master's degree in this. She's worked with, for 10 years, she's worked with stroke patients. Dr. Raja, Dr. Gebel, the defendant's expert, has never worked with stroke patients on rehabilitation, yet he's been upheld as an expert in this case to testify that early stroke, therapy is not needed when everyone else in the community says it is. Ms. Dawson is clearly an expert. I went through the MRE 703 factors in the brief. I can answer questions if you have any of them, Your Honor, but she's been trained in this. She has specialized, focused knowledge on this. She knows Ed Nellis' case like the back of her hand, knows exactly what therapy he had. She can cite to the authority that taught her, on top of her own personal knowledge and training, that early stroke therapy is necessary and that you will not achieve the same degree of an outcome if you do not get it right away, because, and this is confirmed by the defendant's very own witnesses, because the neuroplasticity of the brain only lasts so long, and it diminishes and it plateaus at about the 6-month mark. And every minute it gets closer to that, it is losing neuroplasticity, and that's time you don't get back. That's what she's testified to. I think she can give this opinion testimony. I think it's completely different than the Infinity case, where again, they were trying to make a medical causation diagnosis for why someone needed therapy. As far as Mrs. Nellis, again, it's not only a party admission, it's a statement made for medical treatment and diagnosis. And she did, I believe, say Dr. Raja specifically, and also other medical providers told her this. This is all consistent, and I think it is admissible under that rule. It's not even hearsay, it's non-hearsay in that situation.
Okay. All right. Number one, I mean, I agree, first of all, with the premise that the plaintiff cited, which is the court has already found that there's a question of fact with regard to how the fall affected the extent to which Mr. Nellis recovered from the stroke. When it comes to Ms. Dawson, and you know, the jury instructions even say this, experts are allowed to give opinion testimony about matters that they're experts on. So first of all, you know, Ms. Dawson's testimony would have to be related to her field of expertise. I think she can certainly testify as to her training, her education, what she learned through that process in terms of the delays and how important it is to treat strokes sooner rather than later. I mean, I think that's common sense regardless, but I think she can certainly testify as to her training, education, and experience in the necessity to get that kind of therapy sooner, and that typically patients are going to have better outcomes the sooner they get into therapy after a stroke. And this is another one where I think it's very nuanced, and there's going to be a fine line, and it's going to have to depend on how the testimony comes out. I mean, I think she obviously can't give a medical opinion that due to the nature of the stroke that Mr. Nellis would have done better. And I think there's a difference between her giving a medical opinion that a doctor or a neurologist or a stroke doctor would be able to give and what Ms. Dawson can give. I mean, obviously there's got to be a difference because they have different qualifications. Ms. Dawson can't give that kind of same medical opinion testimony. But again, I think she can testify as to all kinds of things about how this fall caused setbacks in Mr. Nellis' recovery in particular. You know, whether she thinks he would have done better without those injuries. And again, her training, her understanding based on her experience of strokes and when therapy needs to begin, because she's a therapist. She works with stroke patients. She's qualified to give that testimony, and defendants can cross-examine her. They're going to have more than adequate opportunity to cross-examine Ms. Dawson where they feel there are holes in her knowledge or expertise or so forth. So with regard to Ms. Dawson, I'm denying the motion, again, subject to how the testimony comes in. With regard to Ms. Nellis, I don't think there's any question. She can't give her own opinions about whether she thinks this affected Mr. Nellis' recovery. She's not any kind of medical expert or therapeutic expert. So I don't think Ms. Nellis gives any opinion testimony or would be permissible for her to give any opinion testimony about what she thinks. Statements made to her may be admissible under, you know, the rules of hearsay as party admissions. There may be all kinds of other statements that were made to her by individuals that may be admissible for various reasons. But so I'm not ruling on the admissibility of those kind of statements because, again, I think it depends on how that testimony is offered and the reasons given at trial and when it's offered and through whom. But I'm granting the motion in terms of Ms. Nellis providing any kind of opinion testimony based on her own opinion. So I'm granting the motion in part with regard to Ms. Nellis and denying it with regard to Ms. Dawson. The last one I have for defendants is the motion regarding the stretcher manual. I mean, I'll let counsel weigh in on this, but again, I think this is another one that has to really come up at trial. It seems like, you know, stretcher manual might be relevant to admit that as evidence to the extent that any of the defendants are denying that they didn't properly use the stretcher, or to the extent that, you know, any witnesses are denying their warnings and so forth for impeachment purposes. So I don't know that the court can grant a motion for just a blanket saying it's not admissible for any purpose under any circumstances. Or the court can say, yeah, it's definitely admissible. I think the stretcher manual is one of those things that is going to depend on how the testimony comes in. So I'm not going to either grant or deny that motion at this point. I think, again, that's going to depend on the circumstances of trial, when it's offered, if it's offered, and the reasons for it. So I'm not granting or denying that motion at this time. And if it comes up, then we'll have to address that at trial. Then we have a number of motions from the plaintiff's side. I'm going to address a couple of them just offhand. Number one, taking judicial notice of the laws or regulations of the state of Michigan. I don't know that that's something the court even has to rule on. The statutes and laws of the state and regulations of the state are what they are. So I don't really think that even requires a ruling. Naming the in-court representatives, I would agree that non-natural parties or parties who are non-natural persons, they get one representative. I think we can all agree on that. So I don't know that that's really an issue. Mr. Elliott, are either of those matters that we need to address further?
Your Honor, I don't think so. They have now been named. So now, since this motion was filed, they have named their in-court representatives. And again, that got back to that original issue at the beginning we were talking about. We wanted to know who was going to be in the seat that we could just ask these questions about. And then as far as the judicial notice, no, I don't think you need to rule anymore on that. We were providing the court and the parties notice of that, as well as the specific law we were talking about at the time. But no, I think that'll be in something, again, it was, overabundance of caution that we put it into the motion.
Sure, okay. And then part of your motion was to preclude the defendants from referencing the dismissed counts. I'm assuming that, or I took your motion there to mean that, you don't want the defendant saying, well, they tried this and they tried that and the court dismissed those. And so that shows that the plaintiffs, aren't really bringing a legitimate claim here. I mean, is that kind of where you were going with that?
No reference to the fact that the court has dismissed the other counts or that the court dismissed Diane Nellis as a plaintiff.
Okay.
The all legal decisions made by the judge have nothing to do with anything factual. And I believe those, it was only during the summary dispute or the governmental immunity. Because, Your Honor, if you recall, you had a period of discovery only related to governmental immunity. And those were when all of these, all the claims were dismissed at that time. Nothing was ever dismissed after the full discovery was commenced. It was all dismissed during the governmental immunity period of the case. And that's why Diane Nellis was dismissed. Your Honor found that she would have no claim under the based on the Governmental Tort Liability Act. So these are all just legal decisions. They have nothing to do with anything factual. And that's why we think they're completely irrelevant and should not be mentioned in front of the jury.
All right. And Mr. Arteav, you're agreeing with that proposition that the defendant shouldn't be able to mention the dismissed counts?
Right. Yeah, I think that just kind of goes hand in hand with the motion we filed. And, since the court made its point and granted that motion, there's no issue on our end. And in fact, with the governmental immunity ruling, I think that ultimately implies that those issues never get in front of a jury anyway. So, we're not objecting to that decision.
Okay. And then finally, Mr. Elliott, your motion regarding the defendant's intent to admit liability.
And Your Honor, they've presented what they've presented. That was, again, more in an overabundance of caution and to prepare for how we're going to have to write these jury instructions. And we have had productive communications with all counsel here, and we all, I think, decided to wait till after the rulings today to take another crack at those jury instructions. But again, that was it. While I don't find what they've provided as an alleged admission of liability to have much bearing, they're fully free to testify to whatever they want when they're on the trial, and we can, I'm sure, put something into the jury instructions now that they've put something in writing. I assume we'll be able to agree on all of that.
All right. Okay, so I don't think I need an order coming out of any of the plaintiff's motions. Mr. Arteev, if you can prepare an order that reflects the ruling of the court as to the defense motions. And then I'd like to move on now to just kind of some trial preparation here to talk about some procedural issues. Again, I've got a list that I want to go through, and then I'll certainly address any other issues that counsel wants to address. So first of all, the composition of the jury. I don't know if this is something that you all have discussed in terms of, and Mr. Lesperance, if you want to jump in here, if you're going to be trial counsel, whether you've all discussed how many jurors you want to seat. I mean, obviously we can impanel 6, 7, 8 jurors. How many you want to have deliberate, and what ratio you want to compose a verdict. So I'll just let counsel, is that something you guys have discussed, or do you think we can agree on that?
We have not. In my experience on a trial of this length, 1 week, we usually add 1 extra juror, so we carry 7. And then I think almost every time the judge asks us at the end whether we want to drop 1 or not, and sometimes people do and sometimes people don't. If they don't, we usually agree on a 5 out of 7. That's what's happened pretty much every time I've seen that come up.
Okay, Mr. Elliott?
We haven't discussed it yet.
Yes, Your Honor. Our proposal is to stick with the 6 to have an alternate, and 5 out of 6 would be able to make the determination. I guess a question to you is, do you find many people not showing up after they've been selected? If that's the case, maybe we'll want to go with a second alternate. I don't know. What are your thoughts on in your courtroom in your county in this particular court?
Yeah, I can't say that there's any recognizable pattern. I would feel more comfortable in a week-long trial seating 7. And if we want to excuse 1 and do 5 out of 6, or if you all decide at the end that you want all 7 and do 5 out of 7, we could decide that later. But I would be a little bit concerned, especially, with weather conditions, northern Michigan, right before Christmas. I would hate to get 4 days in and lose jurors. So it would be my suggestion to seat 7 and then decide at the end. Do you have any objection to that?
I didn't hear the last thing. I didn't hear what you said, the last part, the last question.
Do you have any objection to seating 7?
None. 7 or 8 would be fine with me. I just like 6 to decide.
And at the end of the trial, because this came up once, if Jim, for example, wants 6 and we want 7, you go with 6. So both parties have to agree if you want to keep the alternative on.
Correct.
Yeah.
Yep, I would agree that the court rule provides that it would be 5 out of 6 if we have an extra. So, okay, so we'll seat 7. In terms of peremptories, typically, my view of the court rule is, we've got 2 individual defendants. So we would have 2 lawyers for the defense. They would each get 3 peremptories, which would mean the plaintiffs would then get 6. Mr. Elliott, do you have any objection to that? The reason I do that, and I know the court rule says that where the defendants have, where you have two defendants with competing interests, or where one party, for lack of the technical term, maybe pointing the finger at the other, then each is entitled to 3 peremptories. Because a lot of times I don't know how the trial is going to go out, and while we're sitting here today, it doesn't appear that Munson and Kalkaska are necessarily at odds or have competing defenses. As an abundance of caution and for appellate purposes, it's usually my view to allow each side 3, and then the plaintiffs get 6, so it evens out. But certainly I'm willing to hear argument on that. So Mr. Elliott, what would be your position?
Your Honor, I would be fine with 6. I don't think I would have a problem if we each had 3 also. I'm not sure what the defense feels. If we each had 6, would need probably a really large panel.
That's my concern, is that we would run out of jurors. In a similar situation, I've seen us both have 3. It would just, obviously Paul would have to agree to that, and then he and I would just need a moment to confer before each peremptory was used.
Okay. Mr.
Your
Gray?
Honor, yeah, my client is in the case for a vicarious only position. And I'm trying to get Mr. Elliott to dismiss my client. And maybe if you give me 3 preemptories, he'd be more likely to dismiss me. So for that reason, I'd like 3 preemptories. No, I largely, Kevin's concern is well taken. Are we going to run out of jurors? So I guess that's something we have to consider. I think I'm technically entitled to 3 of my own preemptories, and but Kevin raises a good point in terms of the amount of jurors. That didn't occur to me before today.
All right, so we'll say each side gets 3 peremptories, then 3 for defense, 3 for plaintiffs. All right, and then in terms of voir dire, I do some initial voir dire, some very basic voir dire of jurors, and then I allow the attorneys to do some limited voir dire. I will say that I look at voir dire as being very narrowly tailored. Under the court rules and case law, the purpose of voir dire is to find out whether jurors can be challenged for one of the enumerated reasons for cause under the court rule, and to allow enough information for attorneys to make educated decisions about using peremptories. What I don't view as a purpose of voir dire is for counsel to argue their case to the entire veneer and to the impaneled jurors as part of voir dire. And I point specifically to 2.511C, which says the court shall allow counsel to ask questions. So to the extent that the attorneys are engaging in statements, that's not voir dire in my view. The purpose of voir dire is for counsel to ask questions for the purpose of being able to exercise challenges. Again, not to argue their case to the jury, not to pose hypotheticals, which are exactly based on the facts of the case, and then ask jurors how they would rule. That has nothing to do, in my view, with the purpose of voir dire. So I'm just going to caution all counsel on this. I will stop you in voir dire. Again, it's my view that the purpose of it is to get information to exercise challenges, not to try your case in front of the jury. So I'm just going to caution everybody that I view that very narrowly. But otherwise, I'll give each counsel an adequate opportunity, a reasonable opportunity to voir dire after I do my voir dire. Any questions about that process?
I don't have any.
Okay, in terms of exhibits, typically in civil cases, I ask counsel to prepare a copy for the court, and then copies for each juror of your exhibits so that the jurors each have their own copy of those. I know this case may be voluminous, so sometimes I've had counsel where, there are certain exhibits that they want to prepare multiple copy, a copy for each juror. There are some, that are exhibits that are important to come into evidence, but may not necessarily be, something that individual jurors are going to pour through. So I'll kind of leave that up to counsel as to how you want to do it, but for sure, a court copy of each exhibit. Mr. Lesperance.
Your Honor, does Your Honor use jury notebooks? Because I know that's a way that is sometimes handled, is the attorneys agree to put, certain records or the key records in a notebook.
Yeah, so one thing I was going to ask counsel to do is, to confer, to see if there are some exhibits that are going to be stipulated to, or that you're not going to object to. There are a lot of exhibits that, they're just not objectionable. And if you can put together, exhibits that you both sides know are going to come in, and prepare those ahead of time and stipulate to the entry of those, that can be helpful. And I have had counsel put them together, either as notebooks separately as, plaintiff's exhibits that are stipulated and defendant's exhibits that are stipulated, or as a joint exhibit notebook. And then it's just a matter of the ones that aren't agreed to or aren't stipulated to, that we then present to the jury one by one as they come in. So it would be my request that counsel meet prior to trial, attempt to agree on exhibits, and then put those together in a usable form for the jury. I don't know, does that answer your question?
Kind of, but and just so Your Honor knows, this is one area where we have had discussions and we're trying to work on this. I know that in speaking with Mr. Elliott, sorry, Jim, only because there's two of them. I think there's going to be a lot of agreement on the medical records. We've already agreed, for example, that no one's going to have to lay a foundation for them. But Mr. Jim Elliott brought up a good point. We don't want to flood the jury with so many exhibits that they get overwhelmed. And so what I've seen in the past is that there's like one jury notebook that the attorneys agree on. These are all admitted. And sometimes they're really voluminous. And then the parties each pull out the 20 records that they think they're going to use during the trial and put those into I think it's mock or sample jury instruction 2.114, a notebook that the juries use, and each side can add to the notebook if they want. Obviously, you don't want to put so much in there that they can't find things, but that's something I've seen done a lot, and it really works well during the trial. Then each attorney can kind of refer to the notebook, and the juries can kind of follow along without having such a huge pack of material in front of them.
Yeah, I've not had that happen in a civil case, but that doesn't sound like a bad idea, Mr. Elliott. What's your view on that?
How is it, I guess my question, isn't that exactly what you suggested? In other words, the ones we can agree upon, make copies for everyone. The ones that we are not sure that's going to be submitted directly to the jurors, just put it in a big pile. Because that's my understanding of what you're saying. Kevin's suggesting putting it in a notebook. I'm not sure what you're suggesting adding to or taking from. And my preference would probably, yeah. I mean, I'm fine with the way the judge suggested it. And I think that's pretty close to what you suggested.
I think the only difference is that I think there are exhibits that you and I would agree on.
Correct.
But that neither one of us thinks necessarily needs to be in the notebook.
Okay. Well, I'm gonna have you guys just meet and confer on this. My biggest concern, number one, is that there's a court copy that I can work from. And that the two of you agree, or all three of you agree on a method of presenting it to the jurors.
I think we can do that, Your Honor. And since we get paid by the hour, usually we send electronic ones back and forth, and then we print them all up, and we would bring both Mr. Elliott's a copy and a copy for their client of the notebook, and we would have them all kind of set out the first day of trial, so everybody had one, including you, including the witness stand, and all the jurors.
Okay. Mr. Elliott, is that something that you think you can work together on?
We can work together on it. I'm not sure, who's going to make what copies, Your Honor. I generally make my own copies. But again, I'm not sure if we're talking about something different. Having the exhibits to present to the jury, I understand we can do that. The ones that we think may be exhibits but aren't necessarily going to go to the jury, let's keep them in a big pile.
Right. Yep. Totally agree.
Not give the jurors all the medical records, even though we say they may be exhibits.
Correct.
So I think that's what your suggestion was. I think it's very close to what Kevin is suggesting, and I'm fine with it.
Yeah. Okay. All right. The last thing I have on my list, two things. Number one, the court technology. I'm trying to think. I don't know if as long as this case has been going, I don't know if you've actually been in the courtroom here in Kalkaska. I think we've done all our hearings by video. But we have very limited technology, kind of limited space. It's a relatively small courtroom. So I would just encourage counsel, to the extent that any of you are going to use multimedia or any type of technology, communicate with our clerk's office here in Kalkaska. I would absolutely encourage you to, visit the courtroom prior to the trial, kind of plan things out, because again, and even test things out, because again, I'm very protective of my juries, and I don't want to spend time with jurors waiting because there are technical issues. So I'm just going to ask all counsel, to the extent you're going to be using any technology in the courtroom, that you come here, plan it out, test it out, make sure everything's going to work for the space that we have. Mr. Elliott, do you have any questions about that?
Yes. Who do we contact in reference to that, Your Honor? We've already put a call into the court administrator. We're waiting for a call back. Who do we arrange to get into to be able to get into the courtroom?
Yeah, Teresa Hill is our court administrator. So yeah, she's the right person. So yes, that's correct.
And we can tell her, you said it's fine if we go in the courtroom and check things out.
Absolutely.
Is it like any Monday through Friday, as long as the court's open and nothing's going on?
Correct. Yep. A lot of times the courtroom's open, but our district and family court judge does use the larger courtroom here, the circuit courtroom. So that is something that you're going to want to double check if you're making a trip up. But Teresa will help you with that. She'll coordinate it with you, and we're more than happy to accommodate you coming here and checking things out ahead of time.
Thank you.
Mr. Lesperance, any questions about that?
Your Honor, I've tried a case up in that courtroom before, so I know what it looks like.
Okay. And then the last thing I had, which you've already kind of talked about, you've been working on jury instructions. I would just request that at least the Friday before trial, so I think that's the 12th maybe, if you can send me electronic copies of in Word format so that I can alter them if I need to, and notify me electronically which instructions have been agreed to. And if you can do that section by section. So in other words, the instructions before voir dire, whether there's agreement on those, and which ones are agreed to, which ones aren't agreed to, the preliminary instructions after voir dire, once the jury's impaneled, and then the final instructions in 3 separate groups in Word format. Mr. Elliott, any questions about that part?
No, thank you.
Okay, Mr. Lesbrunz.
Your Honor, it makes sense. Thank you.
Okay, all right. So that's my list. Mr. Elliott, is there any matters just relating to the conduct of the trial that you would like to
Yes.
discuss?
I have several questions. Could you tell us your trial day schedule, time-wise, what it's going to be?
So the first day of trial, jury selection, the jurors report at, is it 8:15 or 8:30?
8:30.
8:30. The jurors report at 8:30. Usually we're ready to go by 9, once we have them all checked in. So that's how we'll start. I go right from jury selection. So once we have the jury impaneled, we'll take a short break, but then go right into opening statements. So depending on how long it takes to pick the jury and how long openings are, we may, if things go really well, we may have the ability to hear testimony the first day. Probably not, but you never know. So just be prepared, plaintiffs, to have 1 or 2 witnesses ready to go that first day, just so that we're not wasting time if for some reason things go quickly. But generally, my trial schedule is 9 o'clock start time in the morning. Take a short break mid-morning, 15 minutes. Take a lunch break of about an hour to an hour and 15 minutes. A mid-afternoon break of 15 minutes, and then end for the day sometime between 4:30 and 5. I try not to keep jurors past 5 o'clock. So wherever there's a good stopping point, a break in witness testimony, somewhere, 4:30, 5 o'clock will end for the day. With the exception of deliberations, and I warn the jurors that the day of deliberations, that they may have to stay after 5 o'clock. Once we charge the jury, it's my preference to keep them here until we get a verdict. That doesn't always work. Sometimes we break for the evening, but I may, keep them here till 7, 8 o'clock before breaking for the day during deliberations.
Okay,
so that's schedule. If there are matters that we need to go over, which typically there are, then we'll do that at lunchtime or after we excuse the jurors for the day, or in the morning, before the jurors come in and we start at 9. So I'll use those off times to the extent possible to address issues that arise during the trial so that we're not wasting time when the jurors are here and they're just sitting in the jury room not doing anything.
Thank you. Do you allow the jurors to take notes?
Yes.
And what time do we have access to get into the courtroom to set up in the mornings? What time is it unlocked?
It'll be open by 8 in the morning.
8 o'clock, okay.
Yeah.
And is it secured at night if we leave files and so forth, or do we need to transport it each time?
No, during lunch breaks and at night, the courtroom is secured.
Okay. And I have a question in reference to the names of the parties. I meant to bring that up earlier with Kevin and Paul. Basically, we have 5 defendants. We have Kalkaska defendants, Munson defendants, 3 individual defendants. I wanted to ask Paul and Kevin, and if it's okay with your honor, because I see in some of the jury instructions, Kevin, you have listed, all of the names, the DBAs, the AKAs, and everything else. What about if we just went with Kalkaska, Memorial Hospital, Munson Hospital, and the three named defendants to make it easier for the jurors and for the instructions.
Totally fine with that. Yeah, Kalkaska Memorial Health Center, I think is the name. But yeah, that covers everything. That's a good suggestion, just so everything doesn't get bogged down.
And Paul, you're okay with that?
Yes, thanks.
Okay.
I think, Paul, what would yours be? Munson Healthcare?
Munson Healthcare.
Okay.
Your Honor, do you want any trial briefs written?
No.
All right.
You had enough briefs? Yeah.
Every lawyer has to go plant a tree after this case.
Yeah.
Well,
Nobody knows the facts like you guys do, but I feel like I've gotten a pretty good working understanding of the facts throughout the course of the case. So,
okay.
Okay, anything else, Mr. Elliott?
Oh, sorry.
If we have an issue that we would like to resolve with your assistance prior to the 15th, would you have a few minutes for us to call on maybe the 12th or not? Hopefully that's not going to come up, but if there's something pressing and we could talk to you before the commencement of the trial.
I do have a 4-day criminal trial set to start next Tuesday. It may not take the full 4 days, so I might have that Friday. But it's a CSC case, so it's going to be a lengthy criminal trial, and that's in Otsego County. I have a 3-county circuit, so I will absolutely try to make myself available to address any issues, because I'd rather do it then than when we have a jury here. But it may be difficult, it may be off hours. But that's my schedule for next week.
And last question, I know we addressed this early on, Your Honor, and you said, let's see what happens at trial, but want to ask Kevin and Paul if possibly we can resolve this issue now regarding the subpoenas for the 2 individuals that are going to be the representatives, if they will allow them to testify so we don't even have an issue once the trial begins.
Well, I don't know what they're going to testify to. I mean, because they aren't parties. They weren't there during the fall or the treatment. I mean, that's what I don't understand is I've never seen someone call a person like that.
Well, I've never seen someone not have someone to respond to discovery questions during the trial. In other words, again, how is it fair, equitable, or plausible to prevent me from asking a question regarding a discovery document signed by, again, the judge was very specific in one of his motions or in one of the orders that they have to be signed pursuant to the court rules. The court rule says an agent or a representative, and you guys kept signing them. And again, I'm not trying to be difficult. I don't want to call you folks as witnesses, but I have to have someone.
What are you worried? Are you worried that we're going to you're going to get in trial and we're going to say, oh, this really isn't our discovery answer? I mean, for example, are you needing them to lay a foundation such that we could just admit that in advance and take that off of your plate of things to worry about?
Well, I'm not sure it needs to have a foundation laid, since I already have the discovery answers and they were signed and dated. So I'm not really overly concerned about that unless the judge thinks I should be. I have discovery answers. Someone has to be able to, if I have a question, they have to be able to answer the question. It's not equitable to have an attorney handle all the discovery and then say, well, you can't question us on any of the discovery. If it's relevant. Again, if it's not relevant, I'm not going to ask the question. I'm just crossing my T's, dotting my I's to make sure if once I look at the discovery closely, if I have to ask a question, I have to have a live person to ask it of.
you know, to the extent you want to put Judy Sporer on the stand, who's just the risk manager, and ask her questions out of the interrogatories to see if she knows them, I guess. I
Well,
don't
you find-
understand
I'm
it,
sorry.
but
I mean, I guess I'm trying to think of this too. I mean, to me, the reason for doing that would be if the defendants are, you know, if the plaintiffs are putting on their case in chief. If you have a fact witness who testifies to something and a different answer was given in discovery, and you want to use it to impeach.
That's, Your Honor, that's my understanding. I've never seen this done before. I think every witness who's actually going to testify substantively during the trial has been deposed, so they can be impeached using their prior sworn deposition testimony. I don't understand how it would work with discovery answers, and I don't think discovery answers are admissible as exhibits, and I just don't understand the issue.
Right. I mean, Mr. Elliott, I mean, how would you be calling one of those witnesses as part of your case in chief to question them about? I guess that's my question. Or
Yes.
Are you talking about you would call them in rebuttal to something that the defendants brought up as part of their case?
No, Your Honor, I believe I will be calling all the witnesses with one exception. And that's the expert. And I've been told he's going to testify live. So I will be calling all the witnesses. So I would be calling Ms. Sporer and Ms. Glasser, if I call them at all.
Right. So what would be the relevance of if you calling them in your case in chief, which is to establish the elements of negligence, causation, and damages? What would their testimony be going to in your case in chief?
It'd have to be one of those three things, Your Honor.
Well, I know, but if somebody who's not a fact witness who didn't have anything to do with it, who's an administrator at the hospital who answered some discovery questions about hospital procedure or something like that, how is that going to go to your? I think I'm having the same problem that Mr. Dwight is having. And maybe there's a way to do it. That's what I'm saying. I guess I have to wait and see. It seems like it would be, from my point of view, something that wouldn't be part of your case in chief, that's something that you would be doing in rebuttal or in cross-exam or something like that.
I mean, they're defendants. And in fact, the attorneys answered for all of the defendants, all 5 defendants. So the attorneys sitting there, they've answered for Ellsworth, they answered for Miller, and they answered for Bryan. It's not just corporate defendants. They all answered for all the defendants.
So you'd be calling them to question the credibility of the actual defendants?
I guess, Your Honor, I'm also kind of. Go ahead.
They're all actual defendants. I guess I don't understand what you're saying. They're all named defendants. They're all liable. They were all brought under that count. Then we have the ostensible agency. It's, again, how do they get a free pass at? That's like saying I can't use any discovery.
No, I don't think we're talking about the same thing. Here's the deal. I'm getting a warning on my Zoom because I only get 8 hours and it's
okay.
Oops.
I think that might be it.
I think we're cut off, Jim. Sorry.
Okay.
I guess we can talk about this more, but you know, I think maybe you didn't receive some of these signed things, but I made sure and I looked before the hearing, and I distinctly have signed.
Okay,
The judge is back.
Sorry. I think we probably could go round and round on this all evening if we wanted to. I think it's going to come down to what happens at trial, and maybe I'm off base, and maybe maybe it's going to be apparent when the situation arises, even if I'm not particularly seeing it now. That happens all the time. So,
well, Nick was telling me off record that apparently he has signed interrogatories from his clients.
Yeah,
So
that,
if he has them and I
thought-
don't, that's fine. Just send them to me.
Yeah, I can resend all those to you for sure. I do have, I think some of them were even notarized. But I think I remember these motions to compel that happened last year.
Okay.
And as far as I remember, I submitted to you a lot, I was looking at them this morning in preparation for this hearing. I have, signed interrogatories from Judy Spoor and on behalf of the Kalkaska Kalkaska entities, and I've signed interrogatories on behalf of Yale and
Right.
Kent and Michael. I'm happy to resend those to you just so you can reference those. And if there's something that we're missing, I'm happy to
Okay.
figure it out and send those over to you as well. So,
All right. Thank you.
sound good?
Judge, I only had one thing to bring up.
Okay.
As far as the jury instructions, do you choose the option for the jurors to wait until they hear all the evidence before they deliberate, or let them start talking and deliberating right away?
It's my position that I always ask the jurors not to deliberate until they've heard all of the evidence.
That's the one we request usually, but okay, so we just know which one to fill out when we're getting them ready for you. And then do you let the jurors ask questions? That's always another option. You choose A or B.
I do, unless both sides stipulate that they don't want it.
Could we let you know that on the 12th? Okay.
Yeah, absolutely. Yep.
Okay, that's it.
Your Honor, I only have one issue to raise as well, and it's in an abundance of caution. We've raised it before. I start a trial in Oakland County Circuit Court on Monday. The trial's scheduled to last 5 days. It should be completed within 5 days, Monday through Friday. I've tried enough cases to know that things do not always go as planned. We've raised this in the past. I just feel like I should let the court know that or remind the court of that again in an abundance of caution.
Okay. All right. And that's fine, but you may want to have somebody from your firm ready to at least do jury selection and get things started, because we absent some settlement between now and then or something else extraordinary happening, we're going to plan to start on the morning of the 15th. Okay. All right.
I just had one question with regard to the plaintiff's motion in limine. You said you didn't need an order. Is that because you have the one we submitted already, or?
No, I don't think we really had a ruling on any of those motions.
I thought we had a ruling that that they cannot bring up the dismissed charges, the dismissed counts, and Diane Nellis is a dismissed plaintiff.
Oh, the defendants stipulated to that. They agreed to that. So
if you want to send a step over, we'll sign it. It's fine.
Thank you, Your Honor. Thanks, Nick.
Thank you.
Okay.
Thanks, gentlemen.
Okay, that's all I have for today. Everybody's free to disconnect. If barring some emergency hearing next week, then we'll plan on seeing everybody on the morning of the 15th. Everyone's free to disconnect. Thank you.
How much snow do you have up there, Judge?
What's that?
How much snow do you have up there?
Depends on where you're at. Some areas got up to close to 2 feet. Some only have 8 to 10 inches. So the lake effect, it can be crazy where it drops and where it doesn't, depending on the winds. So.
I grew up in Traverse City, so I remember those days.
Everybody bring your boots. That's all I can say.
We got them packed. Thank you.
Thanks, Judge.
Thank you.
Okay.